So today's topic is demystifying the effect of this insolvency process on the home buyers. I'm sharing my PPT. It is audible. It can be seen by everyone. It is visible. It is visible.
Not yet, sir. Not yet.
Now it is visible.
Yes, sir.
Okay, thank you. So today's topic is demystifying the process of the home buyers in the real estate distress. So I'm Ashish Singh. So I done some real estate matters. So I'm doing currently 4 real estate matters, which includes the home buyers. So two out of which we had filed the resolution plan, which is pending before the NCLT, and the CRP process is on in the two CRP in two corporate debtors. So my largest, the company in which the real estate which includes in the real estate matter is the having the 3200 home buyers. So we are starting with the what is the status of the home buyers under the code. So the friends, when this code was enacted, home buyers were not specifically included under the definition of the financial creditors or the operational creditor. This lead to the uncertainty with respect to home buyers position under the code. Then there was a case of Nikhil Mehta and Sons HUF versus AMR Infrastructure. In this case, the unclad in Nikhil Mehta, this case held that the amount raised by the developers from the home buyers under the assured return scheme had the commercial effect of a borrowing, and therefore the home buyers were held to be a financial creditors under the code. Hence, were eligible to apply for the commencement of the CIRP process for the real estate developer. So this is the first case when the unclad say or any court said that the financial creditors, home buyers are the financial creditors, and they can initiate the CRP process. So, then there is a case of the Chitra Sharma versus Union of India. Here the Honorable Supreme Court has recognized the home buyers as the financial creditors. Further, to ensure that the home buyers are protected in the CRP, the Supreme Court nominated a senior counsel to represent the cause of the home buyers in the Committee of Creditors, which is a decision-making body in the CRP. Subsequently, to resolve the issue of the status of the home buyers under the code, the legislature enacted the IBC Amendment Act 2018, wherein the home buyers were brought within the purview of the financial creditors under the code. So being the financial creditors, home buyers could not only trigger CRP of the real estate developer, but also be a part of the COC. So there is an amendment in the CRP regulations by the 2018 regulation, which has included the home buyers as a financial creditors. Now, after including in the category of the financial creditor, home buyers has some powers vested in them. They can file the application under Section 7 of the CRP, or they can file their claim as the financial creditors. In the Pioneer Urban Land Infrastructure Limited versus Union of India, the constitutional validity of the 2018 amendment was upheld by the Honorable Supreme Court in this matter, when the Supreme Court observed that in the real estate project, money is raised from the home buyers against the consideration for the time value of money. Even the total consideration agreed at a time when the apartment is non-existent or the incomplete is significantly less than the price of the buyer would have paid for the ready flat. Therefore, he gains the time value of money. Then this Amendment Act 2018 was challenged in the Supreme Court, And Supreme Court upheld the validity of the Amendment Act 2018 when they said that the home buyers will be the financial creditors, and because when they purchase the flat, the value of the flat is much less than the when the flat is completely ready. Therefore, this is a time value of money. On this basis, they said this Amendment Act 2018 is valid, and it becomes part of the IBC regulations. After the 2018 amendment, individual homebuyers started filing some cases of which were motivated by the frivolous reasons or the malified intentions, burning the insolvency tribunals. So many cases were start filing in the NCLT. Individual homebuyers are going to the file the Section 7 application before the NCLT. There are many cases pending for the homebuyers. Then it was necessitated the IBC Amendment Act 2020, which prescribed that at least 100 home buyers or the 10% of total home buyers, whichever is lower, from the same real estate project should support the initiation of the CRP against a developer. Now they changed the law in 2020. They say that if the home buyers intends to file the application under Section 7, then at least there should be 100 home buyers or 10% of the total home buyers of the project, real estate project. They can, whichever is lower, they can file the application with the NCLT as a home buyer. Then there is a case of the Manish Kumar versus Union of India. The constitutional challenge to the 2000 amendment was dismissed by the Honorable Supreme Court in Manish Kumar versus Union of India. The Honorable Supreme Court explained that the rationale behind the confining the home buyers to the same real estate project is to promote the object of the court. Honorable Supreme Court said that uh, the home buyers should restrict themselves to their particular project. Like if a developer has developed a two project and the home buyers of one project is satisfied and the home buyers of the other project is not satisfied, then the project when the home buyers are not satisfied, they can file claim against that project only, not against all the projects of that particular developer. Therefore, this amendment is with respect to this home buyers can file claim only against a particular project, not against the complete or the corporate debtor. The home buyer in one project may not have much of the complaint, while the complaints of the home buyer in another project of the same developer may be serious. Therefore, it is reasonable that the home buyers filing the application be drawn from the same real estate project. So, if the home buyers are not satisfied with a particular project, if they have the grievance in a particular project, the project is not complete or the OC has not been received in due time, then those grievances they can file complaint against this particular project, not against all the projects of that developer. This is what Manish Kumar versus Union of India says. Then what are the relevant forms that are required to be submitted to the RP by the home buyers along with the supporting documents and timelines for filing claims? Firstly, the home buyers are the persons, they are engaged in different professions. They may not, they had uh, they had paid the amount for the allotment of their units to the developer, and developers have not given their units to them in their prescribed time. And normally, what happened that some home buyers also settle abroad, or some home buyers not seen the publication in Form A, and they forget to file the relevant form with the resolution profession. So there are many cases when the home buyers has to keep watch on the publication of Form A. Therefore, the home buyer should keep a watch on the publication of Form A of the real estate company, which should be published within 3 days of the CRP commencement date, as we all knows, in one English and one vernacular language at the place where the registered office of the corporate debtor is situated, and other location where in the opinion of the IRP of the CD conducts material business operations. So they have to keep was they have normally when there's some grievances in the particular project, the home buyers make a particular group of the home buyers, so they can keep watch on that group. Maybe someone knows that the form A has been published for this particular project, and once they know that this company or the project has come into CRP, they immediately has to file the claim before the RP. So they have to, after the publication of the form A, or home buyers has to file their claim within 14 days. It is very important in the real estate company that the maximum number of home buyers file their claim in Form CA within 14 days, so that in the COC home buyers has the say and they may appoint RP of their choice. Because the appointment of RP of their choice is very important. What I had seen from my cases in the real estate sector, that in the Delhi NCR region, where they are the home buyer constitute majority of the COC constitution. In my cases, in one case there is 80% of the home buyers, in other cases there is 97% of the home buyers in the COC. So this COC, these home buyers constitute the majority in the COC. But what happens is that when they have to file the claim after the publication of Form A, there is a limited number of claims received from the home buyers. Therefore, the COC constitute of the financial creditors normally, and the financial creditors appoint their own resolution professional, or they confirm their own resolution professional as the RP of the corporate debtor. Therefore, it is important that if the home buyers has the information that the particular project of the corporate debtor has come into CRP, they should file their claim within 14 days, so that they have the maximum voting share in the committee of creditors, and they can appoint or they can replace the RP with their own RP. Then there is a regulation 8A of the CRP regulation provides for the claims of the creditors in a class. So person claiming to be a creditor in a class shall submit the claim with proof to the IRP of the RP in an electronic form in Form CA of the schedule. When they are filing claims, they should attach along with their claim the relevant supporting documents which is provided in sub-regulation 2 of the regulation 8A, which are the records available with an information utility, if any. If there is records available with the information utility, they should attach that record along with their claim. Other relevant documents including any agreement for sale. Normally when we go for the purchase of a real estate unit, then what we do, we go to the developer and we give the token amount, and they allot the particular unit to us, and they give us the allotment letter. And after payment of some more amount, like minimum amount, they issue the allotment, the agreement to sell, or the sale, the flat buyers agreement, with the details of the installments to be paid to the developers as per the construction link plan, or in any other manner as per the policy of the developers. So they have to attach all the relevant documents they had executed with the home buyers, which may contain the agreement for sale, letter of allotment, receipt or payment made. When the home buyers pay the amount to the developers normally issue the receipts. So they have to attach the receipts along with their claim.
Ashish sir, I have a question.
Yes, sir.
Ashish sir, see, as RP, I have received a claim, and while verifying the claim, I found some documents are not there.
Okay.
And I called for the documents, and that person is not submitting the documents. For how long I can keep that claim in abeyance?
Sir, Shyamji, we will come to that only. We will cover this aspect also. So when we come to that point of this conference, the seminar, then we'll discuss that.
Please, sir.
agreement for sale, then all these documents we have to annex along with the support and along with our claim. So any other document which is relevant for the for as a supporting document that you for the existence of your debt against the developer. Along with the Form C, it is important to submit supporting document as an attachment which will help the lottery home buyers to provide the existence of debt as mentioned here in above. It is also important for the RP how RP verifies the claim. So we'll come to that also. RP has to verify the not only the supporting document, RP also has to verify that this amount paid claimed by the home buyers that they have paid this amount to the developer. RP has to verify this amount has come in the accounts of the corporate debtor. So normally what happens that the RP also called for the bank accounts of the home buyers to have the to verify that this amount has come in the accounts of the corporate debtor. After the submission of claim to the RP shall verify each claim and will upload the list of the accepted claims on the website of the company and also with the ibba.gov.in. So what happens that when RP verifies the claim, they have to constitute the committee of creditors, and after the receipt of the more claims, then they have to reconstitute the committee of creditors. Whenever the RP is constituting the committee of creditors or reconstitute the committee of creditors, they have to upload the reconstituted COC with the IBBI site, and the home buyers can see the claims uploaded by the RP on the website of the IBBI, which is the ibbi.gov.in. This way, the home buyers can satisfy himself that their claim has been admitted by the RP. In case there are any discrepancies with the submitted claims of the home buyers or the claims of the particular is not accepted by the RP, such home buyers can directly address the concern with the RP for the redressal. So in case the home buyers finds that their claim has not been admitted by the RP and he has not received any mail from the RP side for the rejection of the claim or for the asking for more documents with respect to their claim, then they can have it directly address their concern with the resolution professional of the RP. Relevant provisions regarding the timelines within which the relevant forms can be submitted. So this is regulation 12. Regulation 12 of the CRP regulations provides for the submission of proof of claims. So I'm reading out the regulation 12.1, which says that the creditors shall submit the claim. This is the amended regulation, amended recently. It says that the creditor shall submit the claim with the proof on or before the last date mentioned in the public announcement. Provided that a creditor who fails to submit claim with proof within the time stipulated in the public announcement may submit his claim with proof to the IRP or the RP as the case may be up to the date of the issue of the RFRP under regulation 36B or 90 days from the insolvency commencement date, whichever is later. Earlier, the last date for the filing of the claim is 90 days. Now they have amended the regulation. They say that the RP can verify the claim received up to the date of the issuance of the RFRP or 90 days, whichever is later.
Ashish ji,
Yes, sir.
sir, can you change to slideshow mode so then your slide will be more visible?
Yes, yes.
Thank you.
It is okay, sir. Now,
This is better, sir. Thank you.
thanks, sir. So 12.1 has this is the amended regulation, regulation 12. Now timelines for the acceptance of claim by the RP becomes the 90 days of the issuance of the RFRP, whichever is later. Subregulation 3 says the way the creditor in subregulation 2 is a financial creditor under regulation 8, it shall be included in the committee of credit committee from the date of admission of such claim, provided such inclusion shall not affect the validity of any decision taken by the committee prior to such inclusion. This is clear. Then 12A says the abdication of claim. This is also a amended regulation, new regulation, which says that the creditor shall update its claim as and when the claim is satisfied, partly or fully, from any source in any manner after the insolvency commencement date. If a creditor has filed its claim and its claim has been satisfied from any source, then he has the duty to inform to the IRP or the RP, as the case may be, that his claim has been satisfied.
Can we ask questions in between?
Yeah, I think there's many chapters in this PPT. Once we complete a chapter, after completion of the chapter, you can ask your questions. Like this chapter is with respect to the form in which the claims to be filed and the timeline within which the claim to be filed. After the completion of this chapter of this PPT, then you can ask your claim questions. Regulation 13 is also the amended regulation, which says that the IRP or the RP shall verify every claim as on the insolvency commencement date within 7 days from the last date of the receipt of the claim. And the something is coming in between. And the creditors containing name of the creditors along with the amount claimed by them, the amount of their claim admitted, and the security interest, if any, in respect of such claim, are updated. There is a updated regulation 1A, which says that where the IRP or the RP, as the case may be, does not collate the claim after verification, he shall provide reasons for the same. This is the amended regulation, which says that if the RP or the RP is not able to collate the claim within time provided in regulation 1, then he has to provide reasons for the same. 1B says that in the event that claims are received after the period specified under subregulation 1 of regulation 12 or up to 7 days from the date of meeting of the creditors of voting on the resolution plan or the initiation of the liquidation, as the case may be, IRP or the RP, as the case may be, shall verify all such claims and categorize them as acceptable or not acceptable for collision. This is the amended version, which says that even after the last date provided by the regulations, which is 90 days of the issuance of the RFRP, whichever is later, even if the claims received after that date, then RP has a duty to verify the claims and either admit them or reject them, or categorize them as acceptable or not acceptable for collision. So they can verify the claims received 1 week before, 7 days before the date when of the COC meeting wherein the resolution plan is to be voted. Till that date, they can verify those claims and they can categorize them acceptable or not acceptable. 1C says the IRP or the RP, as the case may be, shall intimate the creditors within 7 days of categorization thereof under subregulation 1B and provide reasons where such claim has been categorized as not acceptable for collision. So in case the RP rejects the claim, then RP or the RP has to within 7 days of the categorization thereof under subregulation 1B provide reasons where such claim has been categorized as not acceptable for collision. And put up claims categorized as acceptable under sub-regulation 1B and collated by him to the committee in its next meeting for the recommendation for inclusion in the list of creditors and its treatment in the resolution plan, if any. If the RP thinks that these claims are acceptable, which has received late, then he has to include those claims in the list of creditors, and he has to provide it with the prospective resolution applicant for treatment in the resolution plan, if any, and submit such claims before the adjudicating authority for condonation of delay and adjudication wherever applicable. Now, this is a duty of the RP that after once he has verified the claim, collated the claim, verified the claim, and as per him this is acceptable or it can be admittable, then he has to file a application before the adjudicating authority for the condonation of delay. This is the amended regulation, amended recently, I think on 15 February 2024. The list of creditors shall be available for inspection by the person who submitted proof of claims, and this is a normal thing, available for the inspection by members, partners, directors, and guarantors of the CD or their authorized representative, displayed on the website if any of the corporate debtor, filed on the electronic platform of the board for the dissemination on its website, provided that this clause shall apply to every CRP process ongoing and commencing on after the date of the commencement of the CRP regulation 2020. So this amended regulation will be applicable on the every ongoing CRP. This list of creditors also to be filed with the adjudicating authority and presented at the first meeting of the committee. Because all the RPs are present, this session is for especially for the home buyers, so we can discuss the form CA also, the prescribed form to be filed by the home buyers. So if you permit me, then I can share this form. We can discuss the form CA also.
So let's do it.
Yes. This is the form CA, form for the submission of claim by the financial creditors in a class under regulation 80 of the CRP regulations, which already discussed. This has to be given by the home buyer from name and address of the financial creditors, including address of its registered office and the principal office. It is to be addressed to the IRP or the RP, then address of the IRP or the RP as mentioned in the form A. Subject should be the submission of a claim and the proof of claim. The particulars, this name of the he has to mention the name of the financial creditor. Hereby submit this claim in respect of the corporate CRP. Details of the same are as set in below. The name of the financial creditor. So he has to mention, the home buyer has to mention then his name. Identification number of the financial creditor. If an incorporated body provides, he can mention his identification number, the GST number, PAN number, anything. Then the address and email address of the financial creditor of the for the correspondence. Total amount of the claim. Details of documents where reference to which the debt can be substantiated. So he has to mention all the documents he is lying for the for his claim. Here he has to provide all the documents he has for the verification of his claim, like the allotment letter, business buyers agreement, receipts, everything he has to include along with his claim. Details of how and when debt incurred. He has to give reasons how and when the debt incurred. Like he has applied for the allotment of a unit, then he has signed the business buyers agreement, and he has allotted a particular unit of this flat, and he has paid through the bank account. He can mention everything for the convenience of the RP or the IRP. So details of any security held by virtue of security and the date it was given. Since we are talking about this home buyers, normally when we issue the allotment letter, the BBA, business buyers agreement, don't constitute any security on the units, because it is an incomplete unit, and therefore it can be considered as unsecured claim. Details of the bank account to which the amount of the claim or any part thereof can be transferred pursuant to a resolution plan. So he has to provide his bank account details, list of documents attached to this claim in order to prove the existence and the non-payment of the claim, and the name of the insolvency professional who will act as the authorized representative of the creditors of the class. So we have to, RP has to provide 3 names for the authorized representative for the creditors in a class, and they have to, Homebuyers has to choose one person, one IP as the authorized representative through e-voting. And normally, as per the regulations, we have to appoint a authorized representative as voted by the home buyers, and then we have to file with the adjudicating authority. And once it is confirmed at the adjudicating authority, then he can act as the authorized representative of the creditors of the class. So this is all about the Form CA. So the peculiar situation as the allotment in some cases is very old, and documents relating to the allotment and proof of payment misplaced and or not traceable. As Shyamji has asked before, there's some cases come before the RP where the old documents or the old papers with respect to their allotment or the purchase of the unit has been misplaced. Then it is to be taken care that the RP, while verification of his claim, he has to verify the claim only from the books of accounts of the corporate debtor and the CRM data if he receives the CRM data from the corporate debtor. Normally, this client relationship management CRM data is maintained by the promoters or the developers in some software form, or sometimes it is also in the Excel format. In whatever format RP receives the CRM data, he can verify the claims received from the home buyers from this CRM data. These developers maintains the CRM data to manage the bulky data of the home buyers and to keep the records of the payment made, etc. In many cases, the one unit holders transfer his units in between to the other person, and all these particular the history of the transfer comes in the CRM data. So in many cases, once one unit holder has transferred his unit to the other person, both the unit holders file their claim, maybe thinking that the RP may not have all the information. Therefore, it is very important if the RP who is dealing in the real estate matter has this CRM data or CRM software or in the Excel format to have the complete record of the home buyers. The RP has to verify the claim based on the records of the corporator, and there is no other option. Or he can collect the claim on the basis of supporting document also if the RP don't have the details of the corporator or the particulars of the home buyers. So Shyamji asked, in case what happened when the documents misplaced. Shyamji, you can share what was your query?
While verifying the claim, I asked for some documents which were not there in the claim.
Okay.
Now he is not submitting the documents for so many days. My question is, for how long I can keep that claim pending with me?
When because last date for the verification of claim has been mentioned in Regulation 12. So we can wait only till the time we can verify the claims, like which is the 90 days of the issuance of the RFRP. We have we have to verify the claim within this period only. I think we cannot keep it pending for the unlimited time.
Okay, in that case, we will send it back, or we'll write not acceptable or reject it.
So we have to provide information to the prospective resolution applicant in the IM, and we have to provide all the details with respect to the home buyers in the IM.
Right.
If it is pending claim, then you cannot mention in the IM that this claim about this claim which is pending. Therefore, we have to.
But see, Ashish sir, the claim is stuck because of not submission of further documents.
Yes.
Even in that case, I have to put it in the IM.
But it cannot be put as a admitted claims.
It cannot. It will not be as admitted claim, right?
Yeah. You can say that we have received this claim, but it has not been admitted.
They are pending.
But it has that. I think it will be treated as the cancelled claim or the not admitted claim only.
See, I have some apprehension about this. कि cancel claim में कैसे डालेंगे उसको?
Not
Yeah.
cancelled.
Or rather,
in my view, we need to mention the claim received or not yet verified, and this need to mention in the IM also, as it remains a contingent liability for the SRA.
correct.
Even
Yes.
we did like this only in our IM. All the claims which were received but not verified, and moreover, when we have from the books that there are some certain, home buyers are there, but they have not yet filed their claims. Even there it was mentioned in the IM that there are many more buyers who have not yet filed their claim, but they may come in future, and SRA should take into consideration that as well before filing their plan. So we mentioned that as well, the amount.
If you have all the data.
Absolutely. Not data, but the
Right.
amount mentioned. These are contingent liabilities there, that this amount of claims have not been received, but they may come in future because they are appearing in the books of accounts. And NCLT has also made it mandatory now. IM, you have to mention if you in your books any creditor is appearing, but he or she has not filed the claim, we need to mention the IM that there are some claims. As per the books, creditors are there, claims have not been received. So SRA will take into consideration that amount as well before filing their plan.
Yeah.
Right.
That has been dealt in this Puneet Kaur matter, no? That we have to.
Also, they have said this. Why didn't you mention? Although I mentioned, they said they should be clearly mentioned the IM that there are many more creditors who have not yet filed their claims, but SRA has to take into consideration as a contingent liability that they may come in future, and plan will have a clause for those claims also which are not been filed. Some provision has to be made for that also in the plan.
Right.
This was a view of the bench. Actually, it may vary from one bench to another bench, but this was a view of one of the bench in the Delhi NCLT.
As per you, it will remain pending.
Yeah.
Till the
And
final.
You are giving all the information in
Verified.
the IM, no?
Yes, we are
I
giving all the information,
claims
but claim will remain pending in the books of the
not
RP.
verified. Yeah, we cannot admit it unless we have all the documents in our records.
It can also happen that if we have received some documents, like we have received the BBA, but we don't have the receipts, the payment made to the home to the developers,
That
then we
case.
can take some affidavit of the indemnity bond that if there's any loss to the corporate debtor, then he will make good the loss.
In some cases, receipts were not provided by the home buyer, so we check from the bank statements of the corporate debtor and from the tally also whether entry has been made or not. In case there was an entry that something was received, and we can ensure and confirm it from the bank statement of the corporate debtor, even then we accepted the claim even though receipts were not submitted with us.
Correct. So we can do like that also. Yes. But we can, in case some documents are missing, then we can take the affidavit. What practice I maintains that I take some affidavit on the indemnity bond if in case some documents are missing. They had provided many documents, but some documents are missing. I take the indemnity bond, and in case some major documents are missing and his payment, he has given the payment proof like the bank statement, then I also take, if the BBA is missing, then I will also take normally the practice of RP to RP, we can take the copy, ask them to file an FIR and take the copy and indemnity bond on that basis we can we can admit the claim.
Like
We
in
can, yes,
BBA is not executed on time. And in some cases, there were some cases wherein the BBA was signed by the corporate data, but was not signed by the home buyer because of some discrepancies or disagreement on its terms. But he made the payment. So if he has made the payment and we can substantiate that from the bank statement or receipt, we have admitted the claims.
yes. After satisfying ourselves that his name is coming in the CRM data, or he has his payment details are coming in the tally data or the bank statement, so we can do some like we should be flexible to accommodate those home buyers and take the affidavit, indemnity bond, or any other document to admit them as the home buyer.
May I speak also a few words?
Yes, sir.
In my understanding, even the affidavit and indemnity bond is not required, because once the home buyers has actually made the payment, say for instance, he has made the payment in accordance with the other home buyers have made the payment for the same area. If it reflected in the bank statement and some email communication is there, some communication is justifying him, that's enough. Because regulation doesn't say so that we have to verify or we take the bill whether he has entered into a builder buyer agreement or not. He may not have builder buyer agreement, or you're right, in case he says he lost the document. In that case, we would say if you get the copy of FIR, have you got some NCR or not? So he has to necessarily go and get the NCR done.
Important thing is, sir, we have to satisfy ourselves that he is the home buyer. For that
That is why verification, because what the regulation and law says we have to collate and verify the claim as per documents of the corporate data. So corporate data documents reflects that the payment is there. Corporate daughter has taken money as home buyer. So now we are satisfied according to my understanding as per regulation also.
makes sense. The second case may be the in case of death of the originality. So in many cases, the project is started in 2004 or 2010, and the originality expires, and
So that
he
in
have or
that
he may not have the will.
then in that case we have to actually take we need some document to satisfy who would be actual beneficiary of this. Then firstly that we have to take the death certificate that he has expired. We need a proper death certificate, and thereafter what we require that there should be some will.
Yes,
If there is no will,
definitely
then
we
he has
need
to
the
write
death
a
certificate.
affidavit. Yes.
We should have the death certificate of the if the on the case of expiry of the originality, but if we can get the succession certificate, then it is the best thing.
The best thing. In many of the cases,
It,
they are not getting succession certificate and nothing. They are staying somewhere
takes
else. They
long
forgot
time
and
for getting the succession certificate. In
Hmm.
those cases, we can have a NOC from the all the legal heirs, or we can take the indemnity bond from the.
Yes, that can be right approach. That is the right approach.
But we should try to accommodate the successors of the this originality who is now
Original.
expired.
Even after admission of claim, the RP, suppose we have admitted the claim, say for instance. So RP has power to revise it. If suppose I come to know the document is deficient in nature. So we can ask them to no, please produce the succession certificate. You have time, don't worry. We'll admit, you will take, consider your time. You take succession certificate if you can get it easily, or you want to find out something. So it is not even after admission. If we come across some other details, information, so we can update the claim.
Right.
So accordingly, if we find that no, there has to be some more documentation, in that case, we can also ask him to, your claim was however admitted, but these chains are missing. Please provide these documents or either provide these things.
Then there may be case where the payment of constitution is made in the form of cash. So in my practice, if that cash is reflecting in the bank statement, bank accounts of the books of accounts of the corporate debtor, or in the CRM data, then we may accommodate those home buyers, and we can consider this constitution paid against the allotment. In case it is not coming in the books of accounts of the corporate debtor, then we should not accept the claim when paid in cash.
Generally, any payment which is made in cash does not become part of this CIRP process. Actually, it becomes a very difficult task if the payment is made in the cash, because in that case, you need all the required documents stating that the cash, whether he has received the cash receipts, he deposited the amount in the bank account or not, then all those details are required. In that case is very, very risky for the
Yes,
RP
yes.
to actually
Cash entries can also be manipulated by the promoters.
No, cash entry can be promoted. In that case, can be done. If the entire payment is cash, we don't accept it. If the entire payment is, suppose partial payment is a cash, a small amount. Say, for example, he say he has to pay 30 lakh rupees. He has paid 25 lakh, 26 lakh rupees in bank account and 4 lakh. He is showing receipts. That makes sense. But he brings 2 lakh rupees, receipts of 28 lakh rupees, 26 lakh rupees and 4 lakh rupees in a payment. That is not accepted. We only admit 4 lakh rupees as his payment.
Right. Even if it is coming in the books of accounts of the CD?
How do we know it is coming in the book?
If,
In
if
his
we have
name, it doesn't
tally of
come.
the corporate letter and it is coming in the tally,
Generally,
on
they
we
don't.
have the
They
CRM
use
data.
the cash. Now they use the cash actually. They don't deposit in his name.
Correct. Yes. But
Sir, actually, my view is that, the moment the company is in the process of getting admitted into CIRP, then the promoters change a lot of entries in the books of accounts. So you cannot blindly trust such entries.
Yes,
This
yes,
has
correct,
been my
correct.
experience
Yes,
because
yes, yes.
I have come across that maybe they are because they prepare for insolvency 2 3 years ahead of CIRP date. So they do all kind of fabrication in the books of accounts. Assuming you can take these entry on the face of it, what will happen? Sometimes they, in my case, what has happened? The promoter has debited himself the cash. Now, what is the option left with me? I only can file the PUF application, and that would be of no use because his personal insolvency would start. So ultimately, result would be that the person in whose favor they have created entries will get the benefit.
Yes.
So I think getting into cash related transaction, that too by IRP, is a very high
Very
risk.
risky. Very, very risky. We should not actually refrain from actually indulging into. Some claim has been filed to me in one case. He says he has met 2 crore rupees cash, or he has all received. So I have to straight away reject. From where you will show 2 crore rupees entry? If you want to go to NCLT, let him go to NCLT. Let them NCLT decide his 2 crore rupees is okay. Or either he should go to civil court or get the decree of 2 crore rupees. How can we actually decide something like?
so our unanimous view is that we should not consider cash as a concession amount against the allotment of unit.
Yes. Of course, not in rare case. Some small amount in
No,
rare
Ashish
case.
sir, actually,
Good
Mr.
challenge.
Chandra is right. See, if the amount is, it's not a substantial one,
Yes.
then we can consider for that amount.
Right. And there
Yes,
should also
the
be
normal case,
And provided
cash to
provided
payment.
provided they are in the books of accounts.
yes.
Yes, of course. Provided in book
Yes,
there is
yes.
a cash receipts, totally signed, counter signed, and everything. And
Right.
then also
Correct.
take affidavit for this.
So
Yes.
three layer precautions.
3 layers of precaution. Even a small amount of cash is there. If we are going to
Right,
admit
right.
even 2 lakh cash, otherwise we should not admit even a cash transaction. Straight away reject. Let the NCLT decide.
There are 3 cases I mentioned. If you have any other case, you can explain that case also.
Say for instance.
I had mentioned 3 cases in this PPT.
Oh, sorry. Yes.
This has happened for the home buyer. If
So
you
whether we
have
have
any
discussed this
other case as
Pradeep
per
Singh
your
Soni.
experience, we can share
Yes.
those experience also.
So we had discussed all, I think, 2 things. You are asking my other gentleman, I think.
Yes, other than if
Okay, thank you.
IP is present here, has any other experience with respect to verification of the claims of the home buyer, they can share their experience. Okay, then we are moving to the very important
I'm
case.
Kairav Trivedi. I just want to add just one point. When we are talking of rejecting a claim of any person, whether it's a home buyer or otherwise, what I understand is that as an IRP or RP, we do not have any right to reject any claim whatsoever. So we have to put the facts and just put it, if required, let the bench look into it, rather than we deciding that whether this case is accepted, not accepted. If he's giving on affidavit, if he's giving it in writing on affidavit, and we are not able to correlate it with the books of account, then we are not the one who can reject it. See, here we are talking of a right of a financial creditor, and we are talking of home buyers. Now, they are also financial creditors. We are not accepting a claim of a normal operational creditor wherein we can say we are accepting or not. They are also financial. The right has been given. It's a beneficial provision for them also. And we don't, as per legal, to whatever legal knowledge I have, RP or RRP is not authorized to reject any claims. He does not have the authority to reject claims at all. You can always say this is not appearing in the books of accounts. This may be the reason. That may be the reason. But that we cannot reject it. That's what my. Especially,
Mr. Trivedi, the question is
I'm
the
sorry,
same.
you
For
cannot
how long
reject the claim.
we can keep it with us?
We have to
it's not
reject
a
the
question of
claim. There is a
keeping it.
law which says you should reject the claim, my friend.
Sir,
The law,
in
Which
one of the
which clause it
cases,
says we are not authorized to
sir,
reject any claim, my friend.
No,
uh,
my
we cannot
friend,
reject the
law
claim.
says
Shirendra
ki
sir,
reject the RP will reject the claim.
no, Shirendra sir, we cannot
No,
reject
no,
the claim actually.
we cannot reject the claim.
Karanji,
We do not have authority for rejection.
in one of my case, what happens is that a FAR owner in a project has filed his claim as the home buyer. FAR owner means he has to build the building, and he's a kind of promoter of the corporate debtor. So in that cases, if a promoter is filing his claim as a FAR owner, as a home buyer, then we have to reject his claim. We
Yes.
don't have any other option.
No option. We have to exercise this. Unless you reject the claim, he will not go to NCLT. How will go to NCLT? If you keep pending, then he'll blame you कि he neither accepted nor rejected, kept it pending. So we have to reject it so that he go to NCLT.
In the case of genuine home buyers, we can keep it pending as Manisha ji saying.
Of course.
But,
In case of
but
genuine home
in
buyer,
case of this kind of claims, which like the financial creditor is filing claim in the FC in class, then we have to reject his claim.
yes. In my case, what happened? A person has actually filed a claim as a home buyers of a large amount of 5-7 flats. The rate of the flat at that point of time was 30 lakh rupees, 35 lakh rupees, but he was getting the same plan in 1 crore rupees. So if prima facie is appear, I rejected all the claim. I straight away rejected the claim, and you will be surprised there is no application against me. That rejection has been claimed. So proper rejection, proper order and reason, and proper straight away rejection, and there is no application till now.
In some
6
cases,
months have
what
passed.
happens is that somebody has filed the claim on the basis of a MOU that the promoters has allotted, say 20 flats to him just before the commencement of CRP.
It is also falls under rejection.
It can also be rejected.
Yeah, of course, it falls under total rejection. We need to reject actually.
Yes.
CIR, IBC gives power to us to reject the claim.
We will not say the rejection, but we can say that we are not accepting your claim.
The proper word is that your claim, in view of the aforesaid, we are not in a position to entertain your claim. That's all. That is the way of saying. We are not saying we are going to reject.
Yes, that is fine. We are agreeing with that we cannot write the claim is rejected.
Meaning by is that we are not, rejection doesn't mean that you see, rejection doesn't mean you are ousted, we kick out somebody. No, we say simply we have to write it simple. Since due to a forced reason, we are not in a position to entertain your claim. Thanking you. But that's all.
Right.
This is rejection.
So there is a very important case in Greater Noida Development Authority versus Prabjit Singh Soni. It was ordered on 12th February 2024. Here, the Honorable Supreme Court, by its judgment dated 12th February 2024, held that the category in which the claim is submitted is based on the own understanding of the claimant. There could be a situation where the claimant in good faith may place itself in a category to which it does not belong. However, what is important is that the claim so submitted must be with proof as to what could form proof of the debt of the claim is delineated in sub-regulation 2 of regulation 7 and 8 of the CRP regulation. Here the Supreme Court said that the category in which a claim is submitted is based on its own understanding of the claimant. There could be a situation where the claimant in good faith may place itself in a category to which it does not belong. Or what is important is the claim so submitted must be with proof as to what could form proof of the debt of the claim is delineated in sub-regulation 2 or sub-regulation regulation 7 and 8 of the CRP regulation. So it says that even if the claimant has filed their claim in a wrong form, the RP has a duty to verify his claim, and he
Yes.
may categorize the claim in some other category.
Yes.
This is what happened to me on the basis of this judgment. In one case, like I said, that one this FAR owner has filed his claim as a home buyer. Then I rejected his claim, and not rejected his claim. I asked him to file his claim in a proper form. This is an incorrect form. You file your claim, please, in a correct form. Then he filed application with the NCLT. In the NCLT, referring to this judgment, he asked me, RP, to verify his claim in any category RP wants, with reasons, by giving reference to this judgment. So we have to, RP has the now duty to verify the claims even if it is received in a wrong form. We cannot reject them on the basis that this form we have received this claim in a wrong form. So this is a very important and material judgment of the Supreme Court.
I have one point on this. May I add?
Yes, sir.
2 months back, what happened? 3-4 months back, GNIDA have filed a claim in my project in Form C.
Yes.
So I wrote that since you fall under the operational creditor, therefore file in the correct Form B. So they have not filed. I have written 4, 5, 10 mails. Then the time of IM has come. So I have to give in information. I have given information in IM. Then before this judgment, what I have done, I have admitted his claim in Form B. Though he had filed in Form C, but I admitted the claim in Form B stating. So I thought let it admit in Form B because resolution plan was at this stage, because it will create a lot of problem. And then fortunately this judgment has come. So this judgment basically says that now we cannot reject the claim only because of Form A, B, or C, whatever he files. We have to see if he falls under allotee, creditor in clause, or operational creditor, or financial creditor. That's all. But one time, I think my view is that we should at least write one time that you have not filed your form in correct form. Please file it in a correct form. Even if it doesn't so, then we need to accept it. In view of this judgment, I have read so. But it is my understanding.
All the claims of Noida and Greater Noida has been filed are filed in Form C only.
Yes, they file only Form C. They don't file in other form.
Yes, yes.
Yes, right.
So what is the current position for the Greater Noida authority, sir?
They are filing Form C still. Now they are the secured operational creditor now. Na?
See, from the very beginning, they are treating themselves as financial creditor.
Yes.
Okay.
आप जितनी बार भी उनको बोलो, mail करो, they'll not get back to you.
They
will
won't.
not revert.
But fortunately, what happened? They file an application that RP is not accepting my claim. By the time I have accepted in Form B, then he said that RP has moved an application for condonation of delay. As per new regulation, RP has to move application for condonation of delay in view of 18th August 2023 amendment. So I moved an application for condonation of delay, got the condonation accepted in Form B. His application he had no answer to actually in court. So they file in Form C. Now as per law, they become secured operational creditor.
Now my small question is, Sharindra sir.
Yes.
Now, how this Noida issue will be dealt with?
Now Noida issue will be dealt with. We have to deal with them as a secured creditor, secured operational creditor. And we have to accordingly make provision for them, meaning thereby that we cannot give the earlier what we were giving 5 crore, 10 crore kind of thing against 200, 300 crore claim. We have to categorize them properly. If suppose there is a financial creditor, we are giving haircut to 70% haircut to financial creditor, so then in that case, we can give 70% haircut to them also. But we have to treat them as creditor, some secured operational creditor. Or
now this is
otherwise,
acceptable
if
position.
home buyer, no other creditor is there. So we have to categorize as an operational creditor in class and give certain respectable percentage.
Okay, Sharindra sir, you're adding one more class. You're adding one more category, secured operational creditor in a class.
No. Secured no, I'm not saying that. Secured operational creditor, not in a class. I'm sorry if
yes. Yeah,
not in
I
class.
heard like you are saying secured operational creditor in a class.
It
Fine.
may be,
See, I have a case with 100% home buyers,
Hmm.
and Noida is also there.
Hmm.
Now, where will Noida stand?
Noida will stand as a secured operational gate.
So, on priority before the home
On
buyers?
priority, yes.
हाँ, तो home buyers के केस का तो मजा बज ही जाएगा.
Of course they will get it because this is their land, na. If suppose they
Correct,
take away
correct,
their
correct.
land, there's
I
nothing
agree.
left.
I agree.
Yeah.
So, whatever
this-
claim have been filed by the Noida, I have to make a provision for that.
Even they write you a mail, ki this is my claim, and make a chart. Then also we have to admit it as operational gate, secured operational gate.
Secured operational guide. Correct, correct.
So anyone has more question on this part, like claim form and the timelines for filing claim? Because
Sir,
we
if
are
you
not.
don't get the CRM data,
Yes, sir.
I mean, if the CD is not cooperating, then how we can get the data?
Then, ma'am, we have to rely on the documents submitted by the flat owner, unit holder, and we have to collect the claim on the basis of the documents submitted by the home buyer.
No, actually, we need to get the list of the home buyers. We are still, I mean, we have still not intimated to the home buyers. So in that case, how we'll get the list?
Only the suspended directors can provide you the list. Or
If they do not cooperate?
if he is maintaining the CRM data, then this company who is maintaining the CRM, you can contact them for the providing these details of the home buyers.
Okay.
Like in one of my cases, the company has a company is maintaining CD is maintaining the CRM data with some company, and they discontinued the maintaining the CRM data.
Okay.
So I contacted this company which is maintaining the CRM data. So they had some details of the home buyers.
Okay.
Yes. So you may contact this company if they
Yes,
were
yes.
maintaining the CRM data with this company.
Okay.
We
If we
have
contact to the RERA department?
We have to be an investigating agency by contacting the auditors, the company secretaries, and chartered accountants.
That all we did, sir.
In one of my case, I contacted these auditors and company secretaries who were filing the details in RERA.
Okay, yeah, that's what.
And I got the details.
Yeah, we can get the details from RERA also, na?
Yes, of course.
Okay, sir, thank you.
Actually, periodically, they have to file their list with the RERA.
Yes.
Mandatorily.
I think it is a better option. We can contact the compliance officer of the company, last compliance officer.
सर वो तो मिलेगा ही नहीं ना जब प्रमोटर ही नहीं मिल रहे.
Sorry, क्या कह रहे सर?
वो तो मिलेगा ही नहीं जब प्रमोटर नहीं मिलेगा तो वो तो वैसे ही नहीं मिलेगा.
कंपनी सेक्रेटरी मिल जाएगा सर और सीए मिल जाएगा.
कंपनी सेक्रेटरी मिल जाएगा मगर they are not cooperating.
अच्छा, okay. RERA, I don't have any experience taking out the information from the RERA. अगर किसी और को है, they may share their experience. I don't have any experience of taking out any information from the RERA. So our next issue is who can file claim as allottees. Now the section 5(8)(f) of the IBC code, which says that the financial debt means a debt along with the interest, if any, which is disbursed against the consideration of the time value of money and includes subclause F, any amount raised under any other transaction, including any forward sale or purchase agreement having the commercial effect of borrowing. This has been changed with respect to for the home buyers only. The explanation for this says that the any amount raised from the allottee under a real estate project shall be deemed to be an amount having the commercial effect of borrowing, and the expression allottee and the real estate project shall have the meaning respectively assigned to them in clause D and ZN of the section 2 of the RERA. Section 2D of the RERA says the allottee in relation to a real estate project means a person to whom a plot, apartment or building as the case may be has been allotted, sold, whether as a freehold or leasehold or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer or otherwise but does not include a person to whom such plot, apartment, building, as the case may be, is given on rent. So this is a definition of the allotee. Here the plot means the plot for the residential purposes only. Like in my case, if someone is claiming being the owner of the FAR, that FAR cannot be considered as plot, because plot is for the final end use. He has to use that plot for his residential purposes or the commercial purposes. The FAR owner cannot claim himself in this category of a plot, because he has to develop the building on the FAR and then he has to sell the apartments or units in that building. So that FAR cannot be considered as plot, in my opinion. Then as per section 2ZN of the RERA provides for the real estate project, means the development of a building or a building consisting of apartments, or converting an existing building or part thereof into apartment, or the development of land into plots or apartment, as a case may be, for the purposes of selling all or some of the said apartment or plots or building, as a case may be, and includes the common area, the development works, all improvements and structures thereon, and all easement rights and appurtenances belong thereto. Because the provision in section 7 says that we can file application under section 7 for the real estate project only. So the definition of the real estate project is coming from the section 2ZN of the RERA. Then again, in the anclet in the matter of the Nikhil Mehta and Sons versus AMR Infrastructure and Nikhil Mehta and Sons, it is held that the amount raised by the developers from the home buyers under assured return scheme had the commercial effect of borrowing, and therefore the home buyers were held to be financial creditors under the code, and hence were eligible to apply for the commencement of the corporate debtor CRP process for the real estate developer. Then the Honorable Supreme Court in Chitra Sharma versus Union of India recognizes home buyers as a financial creditors. Then Honorable Supreme Court in Pioneer Urban Land and Infrastructure Limited versus Union of India, Supreme Court observed that in real estate projects, money is raised from the home buyers against a consideration of the time value of money. Even the total consideration agreed at a time when the apartment is not existence or incomplete is significantly less than the price the buyer would have to pay for a ready flat. Therefore, he gains the time value of money. So here, this Pioneer Urban Land Development Infrastructure Limited, Supreme Court says that the purchase of the flat has the time value of money. Honorable Appellate Tribunal Anclet in Sushil Ansel versus Ashok Tripathi and others provides that it is apposite herein to mention that the Honorable Appellate decree holder do not fall within the meaning of allottees under the code. So in the Sushil Ansel versus Ashok Tripathi says that the decree holders do not fall within the meaning of allottees under the code. Similarly, in the writ petition, the Honorable High Court of Tripura, in the writ petition number this, Shubhankar Bhavnik versus Union of India, says that the decree holders are not the home buyers. Then there is an important case, recent case of the Supreme Court in the Vishal Chelani and others versus Devasis Nanda. Earlier, what used to happen that if the decree holders file their claim before the IRP or the RP, then the RP don't admit them as the home buyer. They admit them as the unsecured financial creditor or in the others category. Now it has been clarified by this judgment in the Vishal Chelani and others versus Devasis Nanda in civil appeal number 3806 of 2023. The facts of this matter is that the appellants are the home buyers who had opted for allotment in a real estate project of the respondent company. Agreed by the delay in the completion of the project, the appellant approached the UP RERA which by its orders upheld this entitlement to refund amounts deposited by them together with interest. In the meantime, proceeding under the IBC were initiated. In the course of the proceeding, after due consultation by the Committee of Creditors, a resolution plan was presented to the adjudicating authority. In that plan, a distinction was made between the home buyers who had opted for or elected for other remedies, such as applying before the RERA and having secured orders in their favor, and those who did not so. Home buyers who did not approach the authority under RERA were given the benefit of 50% better terms than those given given to those who approached the RERA or who were decree holders. So home buyers who had not approached the RERA or any other authority like the Consumer Forum were given 50% better returns in the resolution plan than the person who had approached the RERA or the Consumer Forum. Appellant felt aggrieved. Their application was rejected by the adjudicating authority, and their appeal too was unsuccessful. Consequently, they have approached this court. Supreme Court held that the distinction made by the resolution profession with regard to the class of home buyers who seeks remedies under RERA is artificial and the amount to hyper classification, hence the false approval of the Article 14. Accordingly, such classification is unsustainable. So the Supreme Court said that even if the home buyer has approached the RERA or any other authority, they should be treated as the home buyers because basically they are the home buyers. And being aggrieved, they had approached these courts for the return of their amount, and they should be treated as the home buyers only, not as in any other category. So this is very important judgment. It has removed all the confusion with respect to the decree holders home buyers. Anyone want to discuss anything about this? This is also very important case, Vipul Limited versus Solitaire Build Mart Private Limited with respect to allottees. In the matter of Vipul Limited versus Solitaire Build Mart Private Limited, here the NCLAT observed that the co-developer cannot be financial creditor. So it is a similar case which I had shared with you, that the FER owner has filed his claim as the home buyer. The relevant para I am reading out. To reiterate, the appellant had issued notice to the respondent under Section 8, terming it as an operational debt. So there is some joint development agreement, many agreements between the claimant, and he has been allotted some flats in the project. In the last line, second last line, the Honorable NCLAT is of the view that we are of the considered view that the appellant cannot be termed as the financial creditor as envisaged under Section 57 of the IBC 2016. The promoter or the co-developers cannot be taken as the financial creditors. Financial creditors also, as per this order. So we are discussing that they cannot be treated as the home buyers, but in this matter, Vipul Limited, NCLAT said that they cannot also be considered as the financial creditors under Section 57 of the IBC.
I have a question. If any home buyer has filed any case before NCDRC or RERA and they have an order from their, say example, he has given rupees 10 lakh to the company, but they have NCDRC order or RERA order wherein compensation has also been permitted, some interest is permitted, and now they have the order for CD to pay 15 lakh rupees. And they file their claim for 15 lakh rupees since they have that order, which is not challenged by the CD at that time. Do we have to admit the claim as per the amount given to us as a home buyer, or these orders issued by the RERA or NCDRC, do we have to admit that as a claim?
Yes. In my opinion, only the amount paid for the units should be admitted. Like if they had paid an amount X for the purchase of the unit, then amount X should only be taken as the admitted amount.
Usually
Not
the question that since they have the order from the, these NCDRC or RERA or tribunal, they say
This
ki
is my opinion. If anyone has their own other opinion, they may.
anything.
Can I give my opinion?
Yes, sir.
I have another opinion on this. I'm sorry. May I say?
Yes, sir.
Yes, certainly.
According to my opinion, in case there is an order from some consumer forum, National Consumer Forum or etc., which says that this much of the amount has to be refunded to those, then in that category, you have to do either of the two things. In the first category, either as Ashish ji has rightly said, ki admit their claim as per the allotment letter, etc., or otherwise put them in a separate category. If they are seeking refund, because what happened in consumer court, they seek refund. So in that case, put them in, ask them, if you are seeking this thing, then we'll put you in this category.
But sir, refund is the prerogative of RA. If it doesn't go with that, then what?
No. We are
We
not
admit
saying
their claim
unsecured creditor means unsecured creditor. Unsecured
Yeah,
creditor.
if I accept their claim as a, as per this NCDRC order, ERA order, then they will no more be the home buyer because
Yes, they become.
if they are not a creator of a class, then they are actually a creator for me, whereas the amount is due to them actually.
Other creditors, you say.
No, there are two ways. Actually, what happened, ma'am, now I'll tell you one thing. What what the consumer code does. Consumer code doesn't give any interest beyond what is there in BBA.
Right.
Right. So if the BBA interest they are claiming either by a consumer code or here, they will come to the same interest rate. There is only differences arises where the CD has played smartly. He has given somebody some other rate of interest and to some other rate of interest. Then only this conflict arises. In most of the cases, RERA has a certain specific. RERA doesn't go beyond MLCR plus 1, 9% rate. So IBC itself say 8%. So in any case, builder buyer agreement is beyond this, generally 9% or 12%. Or similarly, this consumer forum also does the same. So there is no problem in admitting the claim as home buyer in class in case it all tallies together.
But if the forum has granted, they have approved the amount which is higher than the amount given as against the allotted flat, they will certainly want their order amount to be admitted always.
So in that case, you have to admit the amount. Then if you are going to admit the amount, not the flat, if you are going to there become unsecured creditor, then they become unsecured creditor in that case. According to my understanding, in somebody has a better view.
Unsecured financial creditor.
Unsecured financial creditor.
So Shalinji is saying that if the intent of the home buyer is that he has filed his claim in Form CA, he wants his flat back after as per in terms of the resolution plan. Then his intent is to take the flat. Then as per the Shalinji, we should not take the interest part as provided in the consumer forum or the RERA. Then we should take the principal amount only.
These home buyers,
as per BBA, we have to take the as per BBA, builder buyer agreement.
If he wants the interest, then we can ask him if he wants the interest, then to file his claim in as a financial creditor. Then we can give him this interest part also.
or compensation, whatever is there in the order of.
Actually, ma'am, what ma'am is saying,
have a different view here.
there are certain cases, ma'am is saying certain cases, the consumer court passes the order with higher rate of interest, compensation, litigation charges, this and that charges, that becomes more than the amount. So this happens when he says he is not interested in flat.
Right.
Therefore, since he is not interested in flat, therefore he comes under the category of unsecured financial creditor.
Right.
Sir, I have a different view here, if I may be permitted.
Please,
Yeah,
please.
please.
We are not the one who is going to decide whether he is a unsecured financial trader or is a financial trader. He has to be treated as a financial trader only. It is very simple. We are going a little bit too strict. I personally feel we are going too strict with a person who has invested a money in a property and he is not able to get neither refund nor able to get it. And IBC is a beneficial provision. If a bank charges penal interest, do we add the penal interest or we say, no, you are not a financial trader, you will not come out this? If the bank charges penal interest at more than 20%, there are NBFCs also, they charge at 20%. Do we tell them, you are not a financial trader because you are charging me at 12%? So that logic is as per my understanding, and if I am the RP, I would be accepting all the claims, including if RERA is an authority which has given an instruction to a home buyer, the claim has to be accepted. Now, whether he opts for a house or he doesn't opt for a house is a decision which he has to take when the RA comes over, not at this stage. He is not going to say, I am a financial trader at this stage and say, I will not opt for a house or I will take a refund. That is to be done when the RA stage,
But
when the
sir,
RA
but
comes
sir,
over.
you have to put him
And that
into
option
the
has been given to
IM.
him, not
You
at this
have to
stage.
put him into the IM as he is desiring his flat or refund.
No. Forget it. See, why should we put it? That is his decision. He has to decide. We are not going to force him or ask him to do anything. He has to decide based on the plan which is received. Suppose if there are two or three applications and one of them has given a good plan,
Yes,
so that
yes,
is his
Mr.
discretion.
Trivedi,
That has to be exercised at that time, not at this moment when the claim is being filed.
In my
as
opinion, sir, if he is filing Form CA, intends is to be the home buyer, then we should accept his principal amount paid against the unit. And there is a provision in the regulation 16A which says that we can give the interest at the rate of 8%
8%.
or
That
the DBA, whichever is higher.
yes, that 8% is only for purpose of determining voting share. That is not for the purpose of giving the amount back to them, to my understanding.
We can admit the with interest as provided in regulation 16A, and it is upon the PRA whether to admit his claim with the principal amount or with interest.
Yeah, the same way we should add whatever extra things are then let the PRA decide whether he has to pay for that extra or not. That is what my contention is. When the claim has been filed by him stating that this is a RERA order, and we are not an authority to say we will not accept the RERA order.
Just filed as per
That's my thought process.
then I don't think he remains eligible for the flat in that case. Why would he get a flat if he has already asked for a compensation and refund of the amount as per ERA order? How can we, allot flat to him later on when the SRA builds the project at later stage? It would be very difficult for us to determine him as that because the order says he need to be repaid and refunded the money. So how can he claim the flat in that case?
Now, if there is any regulation in the CRP regulations for the interest part, then I think we should not take the, if any order of the RERA or the consumer forum says for the higher interest, we have to take what interest is provided in the IBC.
yes, I agree. See, now another situation is when the person is filing Form CA and along with the Form CA, he is attaching that order from the consumer court for the refund.
They attach it.
Then what?
This is how we receive the forms.
Yes.
Correct.
So as an RP, we as an RP, when there is a court order and home buyer himself relies on the certain orders, so we will, according to the order, admit the claim. Say, for instance, the order says he wants refund with compensation. We'll add this amount. Then we have to change his category from financial creditor in class to unsecured financial creditor. That is what exactly I was saying.
He cannot be eligible for the flat in that case. He cannot be.
Because he himself is coming with certain order which says ki you don't want flat. Let's take this money. If he wants
Chandra sir, usually what happens as a home buyer and as a layman, I fill the Form CA and I attach the order of the consumer court for the sake of I'll get the priority.
So Shyam sir, I think my timeline is still only till 4:30. We can go through with the complete slides, then we can discuss.
Okay, fine.
Then the right of the home buyers to file application under Section 7 of the IBC. We already discussed through the 2018 Amendment Act, the home buyers were categorized as the FCE and allowed to file the application under Section 7. However, in 2020, another amendment came in which the position was changed significantly with respect to the filing of the insolvency application powers of the home buyers. So these sections we mentioned, the section 7, everyone knows section 7. So there is a proviso in the section 7 which says that the financial creditor referred to in clause A, B of the subsection 6A of the section 21. This is not with respect to the second. An application for the initiation of CRP against the corporator shall be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors in the same class, whichever is less. Provide for the financial creditors who are LOTs under a real estate project, an application for initiation of CRP against the corporator shall be filed jointly by not less than 100% of such LOTs under the real estate project, or not less than 10% of the total number of such LOTs under the same real estate project, whichever is less. So they are talking of the same real estate project. Now the home buyers, in order to take the defaulting builder real estate company in the insolvency process, we jointly file application for the initial CRP, at least 100 home buyers or 10% of home buyers in the same real estate project. It is also to be noted that the lesser number of in two conditions above mentioned shall be sufficient to file the insolvency application. I think in the matter of the Manish Kumar versus Union of India, we already discussed this application. Here they are explaining how we have to calculate this computation part, 10% of the 100 number of home buyers. The amendment was released before the Honorable Supreme Court in case of Manish Kumar versus Union of India. However, the Supreme Court upheld the constitutionality of the 2020 Amendment Act. However, it is now crystallized that there must be minimum 10% of the home buyers pulling together, or at least 100 of the home buyers of the same real estate project to file insolvency application. For example, in a real estate project, ABC Builders having 1500 LOTs, then the minimum number of 100 LOTs, minimum 100 LOTs are jointly required to file insolvency application against the ABC Builders. 10% is 150, even if they're lesser than 10%, which is 100 LOTs. If they want to, they are pulled together, they want to file application under section 7, they can file application. In another case, in real estate project XYZ, this having 80 LOTs, then minimum of 8 LOT are jointly required to file insolvency application. Here the 100 LOTs need not to file application. Here only the 8 LOTs can file application under section 7. What are the prerequisites of filing application for the CRP under section 7 of the code? There have been different sets of requirements for the financial creditors and the operational creditors for launching CRP. An application under section 7 of the code requires a financial creditor to establish that there has been a financial debt. Financial debt has become due for payment. Default has been committed in respect of the debt. And while filing this application under section 7, a fees of rupees 25,000 to be paid with the application to the registrar of the NCLT. Then what are the remedies available to the home buyers in case of rejection of claim? So many times the home buyers who stays abroad or does not get the information about the commencement of the CRP fail to file their claim in the time, and they face rejection of their claim, rejection or the not approval. The earlier maximum timeline for filing claim was 90 days, which has recently been amended till issuance of the RFRP of the 90 days, whichever is later. Therefore, there is a plenty of time now provided by the regulators for the submission of the claims. So, what are the common reasons of the rejection? Is a wrong word, as we discussed. Not approving the claim. In case the claim has been filed after the 14 days, as mentioned in Form A, then RP has all the powers to verify the claim and admit the claim after the till the 90 days of the RFRP issuance date, whichever is later. In case claim filed after the issuance of the RFRP, then we have gone through with the new regulations 13, as per which RP has now the duty to verify the claim. He has to verify the claim, and he has to make in the category of acceptable or not acceptable, and then he has to place it before the COC. COC has to now approve it, those claims, and after the approval of the COC, then RP has no duty to file application with the NCLT for the condonation of delay of those claims. Once the claim and the NCLT condone the delay, then these claims can be admitted by the RP, and these claims can also be shared with the PRAs, or they can update their IMs. Filing of claim after issuance of the RFRP, but at least 7 days before 7 days from the commencement, from the date of COC meeting when the resolution plan is to be approved. So this is the same case. Before the issuance of RFP, RP has all the powers, and within this time, after the issuance of the RFRP, but at least 7 days before the COC meeting when the resolution plan is to be approved, RP has to comply with the regulation 13. Filing of claims after approval of resolution plan by the COC, but before the approval by the adjudicating authority. If the claim has been filed after the approval of a resolution plan by the COC, then the home buyers has the right to file application with the NCLT and with their reasons for delay. And if the NCLT feels that there is a reasonable reasons for the delay, then they may ask RP to verify the claim, and RP has to verify the claim. Accordingly, they may admit the claim. There may be case where the filing of claims after approval of resolution plan by the COC and the adjudicating authority. After the approval of the resolution plan by the COC and the adjudicating authority, then I don't think the RP has the power to do anything. So the claim cannot be accepted either by the RP as well as the adjudicating authority also cannot direct the RP to verify the claims. There may be rejection because the RP don't find the claimant as home buyers, but in some as a home buyer, but in some other category. There may be case of the non-submission of documents asked by the RP for verification of claim, or there may be any other reasons for the not accepting the claims of the home buyers. This is an important judgment, Puneet Kaur versus KB Developers Private Limited. The issue of the filing delayed claims for the home buyers was highlighted by the NCLAT in this case. The NCLAT took into account the settled legal principle that creditors cannot file claims after the resolution plan is approved by the COC. However, in order to give the relief to the allottees of the home buyers who had filed their claim at a belated basis, NCLAT indirectly allowed the belated claims of home buyers after COC had approved the resolution plan. NCLAT categorically recorded that it was not setting aside the order of the NCLT, rejecting the belated claims of the home buyers as the same was passed, keeping in mind the settled legal principles. Instead, the NCLAT gave an expensive meaning to Regulation 36 of the CRP regulation, which is for the preparation of the IM by the RP. NCLAT held that the allotment of residential unit to the allottees home buyers was a liability in the books of accounts of the CD, and therefore the RP was obligated to include the same in the information manual. Now we have to include the details of the home buyers coming in the books of account of the corporate debtor in the IM. As the Manisha ma'am said, that in the contingency part, we can say that these amounts are coming in the books accounts of the corporate debtor. Therefore, the RPPRA has to provide in their resolution plan for this amount coming in the books account of the CD. Finally, the NCLAT directed the RP to provide all details of the home buyers along with their claim as reflected from the records of the CD to the resolution applicant within 1 month. The resolution applicant was directed to create an addendum based on the aforesaid details and place the same before the COC within a further period of 1 month. COC was directed to consider the addendum in its meeting and place it before the NCLT within a month from date of submission of the addendum by the resolution applicant to the COC. The resultant effect of the decision was that it delayed the CRP by 3 months, while the judgment in KB Developers acknowledged the limitation of the current framework of this code. It did not resort to procedural invention. NCLAT used Regulation 36 of the CRP regulation to make it incumbent upon the RP to include all dues which are mentioned in the books of account, thereby protecting those home buyers who have belatedly filed their claims. This is all about the KB developers. In an important judgment in the Ghanshyam Mishra and Sons Private Limited through the authorized signatory versus Edelweiss Asset Reconstruction Company Limited. Here the Honorable Supreme Court of India in the matter of Ghanshyam Mishra gave much needed relief for all the resolution applicants who are about to face multifarious claims litigation initiated by the disgruntled creditors, including central state authorities and departments, seeking payment of their dues despite the CRP process have successfully concluded with the approval of the plan of the said resolution applicant, having been approved by the AA under Section 31 of the IB, Insolvency Bankruptcy Code. It says that after the approval of the resolution plan by the adjudicating authority, no further claim can be entertained by the RP or by the adjudicating authority. The judgment further strengthens the concept of clean slate, which will go a long way in the restricting or restraining the various creditor stakeholders, including the central state government, authorities and departments, from pursuing the recovery of their dues against the new management of the CD, despite successful conclusion of the CRP process. So this is all about the Ghanshyam Mishra case. There is also an important case in Piyush Shelters India Limited. I'm just reading the judgment part. Here what happens is that the promoters suspend directors has filed application before the ANCLAT saying that the claims received of the home buyers are less than 50%. Therefore, sufficient number of claims has not been received by the RP, and therefore the process of the CRP should be reinitiated. And the NCLT ANCLAT had allowed the application and asked the RP to reinitiate the CRP, and that given time for the 3 months, and they take the claims already received and but ask for the more claims by making publication with in the newspapers. This way, in this case, the claims received by the RP was lesser, and the application filed by the suspended directors was allowed by the Honorable ANCLAT. There is also a issue with respect to the compliance of Section 25A of the IBC. In this case, what happens is that the RP has circulated the minutes, and immediately after circulation of minutes, they initiated the voting process. And there is a provision in the CRP regulations which says that there should be at least 24-hour gap between the circulation of minutes by the RP and initiation of the e-voting process. The regulation has not been complied with, and therefore that has been observed in this case also. Therefore, we have to take care of the regulation with respect to giving 24 hours time while starting the e-voting process in the case of real estate. The participation of the home buyers in the COC meeting through AR. The amendment introduced in the Insolvency IBC Ordinance 2018. By this amendment, new concept has been introduced: the appointment of AR for the class of creditors. As per class of creditors, as per Regulation 21AA of the IBCRP regulations, class of creditors means a class with at least 10 financial creditors under clause B of subsection 6A of section 21. And the expression creditors in a class shall be constituted accordingly. The class of creditors does not mean but include home buyers or the real estate buyers or deposit holders. Class of creditors is a group of 10 or more financial creditors other than banks and financial institutions or trustee in financial securities or deposits. So in the class, there should be at least 10 persons in the same class. The various type of class of creditors can be the home buyers, real estate lotteries, deposit holders, and debenture holders. There can be many classes also. The appointment of AR. Section 21(6)(a)(b) of the code with regulation 16A of the CRP regulation provided where the CD has at least 10 financial creditors in a class, IRP shall offer a choice of 3 IPs and a creditor in the class may indicate its choice of an insolvency professional for amongst the three to act as its authorized representative. The insolvency professional who is a choice of the highest number of creditors in the class is appointed as the heir of the creditors of the respective class. Who can be the heir? Regulation 4A provides for the qualification of the heir. IRP shall identify three insolvency professionals who are not his relatives or related parties, eligible to be IPs under Regulation 3 and the willing to act as the heir of the creditors in a class. We should take consent from the heir who wants to act as the heir of the creditors in a class. Then we can have a discussion in the COC. COC once approved by resolution, then we can file the application before the NCLT. And once it is confirmed by the NCLT, then the heir can act as the heir of the class of the financial creditors. IRP shall obtain the consent of each insolvency professional identified as above to act as the heir of creditors in the class in Form AB of the schedule. Process of appointing heir. As per clause B, subsection 6C of section 21, where a financial debt is owed to a class of creditors exceeding the number as may be specified than the creditors covered under clause A or subsection 6, the IRP shall make an application to the A along with the list of all the financial creditors containing the name of the IPs to act as the authorized representative who shall be appointed by the adjudicating authority prior to the first meeting of the committee of creditors. So we have to file application for the appointment of A much before the first meeting of committee of creditors, and we should see or try that the NCLT approves the name of the authorized representative so appointed by the class of creditors before the first meeting of committee of creditors. And such authorized representative shall attend the meeting of the committee of creditors and vote on behalf of the each financial creditor in a class to the extent of his voting share. 25A provides for the rights and duty of the authorized representative of the financial creditors. The authorized representative under subsection 6 or subsection 6A of the section 21 or the subsection 5 of section 24 shall have the right to participate and vote in the meeting of the committee of creditors on behalf of the financial creditors he represents, in accordance with the prior voting instruction and of such creditors obtained through physical or electronic means. It shall be duty of the AR to circulate the agenda and minutes of the meeting of the COC to the financial creditors he represents. The AR shall not act against the interests of the financial creditor he represents and shall always act in accordance with the prior instructions. Provided that if the AR represents several financial creditors, then he shall cast his vote in respect of each financial creditor in accordance with the instructions received from each financial creditor to the extent of his voting share. Provided further, if any financial creditor does not give prior instruction through physical electronic means, the AR shall abstain from voting on behalf of the such creditors. This is the regulation.
I have one question on AR part actually, if I intervene, very short question. In
Yes.
some NCLTs are, asking AR also to appear before the bench whenever they need to represent the COC there. So they are asking us to make the AR party as a member of party need to be amended as well, because he will represent the COC there. For that purpose, sometimes AR himself appear before the court, and sometimes they are hiring a counsel as well to represent them before the point is any cost involved by the AR for appearing before the court, or if you're hiring a counsel to represent him, how will he get reimbursed for this? Because as per the report, I think only way of remunerating the AR is the sitting fee, which is already prescribed, as per the number of home buyers that he will entitled to. So any litigation coming on him wherever he has been asked to appear for the court through himself or through counsel, how can we reimburse? And he's saying, why should I bear this cost? You are paying me only, the sitting fee of rupees 20,000 for each COC meeting. There we are stuck actually. If anybody has any thought on this, otherwise we can proceed with your presentation.
I have one thought on this. The AR will only get the money whatever has been prescribed in the books. Rest of the money he has to arrange from the creditor in class. Or if he is going to buy, is going to engage some counsel, etc. Those fees are borne by the creditor in class. Not by, that do not form the CIRP cost.
Thank you.
I'm agreeing with the view of the Shalinji.
Thank you.
Yeah. Right. So 25A provides for the rights and duties of the heir of the financial creditors. The heir under subsection 6 or subsection 6C of the section 21 or subsection 5 to section 24 shall have the right to participate vote in the meeting of the COC on the financial creditors he represents and in accordance with the prior voting instruction of such creditors obtained through physical means. We have read this. It shall be the duty of the heir to circulate the agenda minutes of the meeting of the COC to the financial creditors. The important part is that the RP has to provide this infrastructure for the circulation of agenda minutes to the heir. The heir shall not act against the interests of the financial creditors he represents and shall always act in accordance with their prior instructions. Provided that if the heir represents several financial creditors, then he shall cast his vote in respect of his financial creditor in accordance with the instructions received from such his financial creditor to the extent of his voting share. But further, if any financial creditor does not give prior instruction through physical electronic means, the heir shall abstain from voting on behalf of such creditor. Notwithstanding anything contrary quoted in subsection 3, the heir under subsection 6C of section 21 shall cast his vote on behalf of all the financial creditors.
अरे बार-बार फोन करने की जरूरत नहीं है भाई, मैं करा दूंगा अपनी।
श्याम जी,
ये 2 बार इकट्ठे फोन।
श्याम जी,
सॉरी।
Heir under section 6A of section 21 shall cast his vote on behalf of all the financial creditors he represents in accordance with the decision taken by vote more than 50% of the voting share of the financial creditor he represents who have cast their vote. So heir has to cast his vote on the basis of the vote casted by the home buyers, by the majority of the home buyers. If in a resolution vote casted in favor of the resolution is more than 50%, accordingly the heir has to cast his vote for the class. If it is consented, then he has to consent, and it will be considered as this class of the creditor has consented the particular resolution. Provided for a vote to be cast in respect of application under section 12A, the heir shall cast his vote in accordance with the provision of subsection 3. Only exception is 12A, when the vote cast by the home buyers will be taken individually, not as a block or as a class. If in a voting in section 12A resolution, vote cast is by the home buyers are 55%, then 45 is negative, 55 is positive. 45 is taken as the negative voting and 55 is taken as the positive voting. The heir shall file with the committee of creditors any instruction received by way of physical electronic means from the financial creditors he represents for voting in accordance therewith, to ensure that this approved voting instruction of the financial creditors he represents is correctly recorded by the IRP or the RP as the case may be. Then the duties of the heir. So he has the duty provided in regulation 16A, sub-regulation 10. Assist the creditors in a class he represents in understanding the discussion and the constitution of the committee meeting and facilitate informed decision making. Now, as per the amended regulations, AR should have a meeting with the class of the creditors before the COC meeting, and he can have the understanding of what the class of creditors feels about the particular resolution item. Review the contents of minutes prepared by the RP and provide his comment to the resolution proposal if any. So he has to explain the contents of the minutes to the class of the home buyers. Help the creditors in a class he represents during the consultation made by the RP to prepare a strategy for marketing of the assets of the CD in terms of regulation 36(1). Work in collaboration with the creditors in a class he represents to enhance the marketability of the asset of corporate in terms of regulation 3. Assist the creditor in a class he represents in evaluating the resolution plan submitted by the resolution applicant. This is also duty of the heir to explain the resolution plan to the class of the home buyers. Ensure that the creditors in a class he represents have access to any information or the document required to form an opinion or issues discussed in the committee meetings. So, heir has the duty to see that the class of the home buyers has all the informations required for the taking any decisions with respect to where they have to form any opinion. Update regularly the creditors in a class he represent on the progress of the corporate CRP. So he has to update the COC about the what update has taking place in the CRP and what decisions or what discussion has taken place in the COC meeting. Make suggestions for the modification of the resolution plan as may be required by the creditors in class he represent. Record proceedings and prepare the minutes of the meeting with the creditors in a class he represent, and act as a representative of the class creditors in a class he represent in representation before the adjudicating authority and CLT and CLAT and other regulatory authority. So now he can be a representative of the home buyers in the NCLT and CLAT, subject to the approval of the COC, I think. Because if he's charging anything for appearance as a representative of the class of the creditors, then that expenses should be ratified by the COC. Regulation 18 is with respect to meeting of the committee. Regulation 18, a RP may convene a meeting if he considers if it necessary on a request received from the members of the committee, and shall convene a meeting if the same is made by the members of the committee representing at least 33% of the voting rights. For the purpose of the sub-regulation 2, it is clarified that the meeting may be convened under the sub-regulation till the resolution plan is approved under subsection 1 of section 31 of the order for liquidation passed under section 33, and decide on matters which do not affect the resolution plan submitted before the adjudicating authority. So this is the amendment. Now in the case of the real estate, it is important that normally home buyers are not satisfied with the RP and they want to change the RP, and they request the RP that please put the resolution for the voting for the change of the RP. RP now, if they RP don't put this agenda item on the request of the home buyers, then they may apply this provision regulation 18(2), and they may give the requisition to the RP on their email ID that they want to put this agenda for the change of the RP, and they may suggest the name of the new RP with the consent of the new RP. And if the requisition is made is 33% or more, then RP has to put this agenda before the next COC meeting, and this agenda should also be put for the e-voting.
आशीष सर, बस एक मिनट की क्लैरिफिकेशन है प्लीज है।
हाँ जी, हाँ जी।
मनीषा मैम, आपने कहा था कि एआर के एक्सपेंसेस है, अगर लीगल एक्सपेंसेस है उसके एडवोकेट्स के, देन वेदर दिस विल बी पार्ट ऑफ द सीआरपी कॉस्ट और नॉट, दिस वाज योर क्वेश्चन मैम?
हाँ, ये बोला था मैंने।
हाँ, तो इसमें हम लोग एक रेगुलेशन 31 है जिसमें आउट ऑफ पॉकेट एक्सपेंसेस को सीआरपी कॉस्ट माना गया है एआर की, whether it will include in that one or not.
Regulation 31.
Yes.
Regulation 31 is with respect to CRP cost. इसमें कौन सा क्लॉज कह रहे हो सर आप?
31A,
31A double A, out of pocket expense of the AR for the discharge of its function under section 25A.
Now, as AR, if I hire an advocate, whether it will be covered in under this regulation or not? Surinder ji.
According to me, it will not cover. Why? Out of pocket expenses or other expenses such as AR has to travel somewhere. So these are the part of out of pocket. Not hiring the counsel. But if you are going to hire the counsel, please hear me out. If you want to hire a counsel, then in that case, this will not form the part of the CIRP cost. It will be taken from the home buyers separately. If someone has a view on it.
Because he is filing application on behalf of the COC.
But sir, now a greater responsibilities have been shouldered on AR now.
COC expenses cannot be borne by the cannot be treated as
actually this is the RP who's taking care of all these things. AR responsibility is to coordinate with them And why AR is contesting if suppose AR is home buyers, if suppose what happened in some cases, home buyers want to contest against what? Against the RP or what? Please.
Yeah, RP.
If against the RP, if they are going to file some application, they have grievances against that application. How that will not form the part of the CRP, because who will pass this agenda in COC?
No. One second. Sorry. This is not the only point what they are talking. The reason that if you see specifically what is mentioned is that now our AR would be going and representing home buyers in front of adjudicating authorities. In that case, yes, whatever lawyer fees are there, why it has to become part of CIRP. I don't think it's only that home buyers will pay for it.
Can you show us any regulation where it is mentioned? Any fee out of
it's not there anywhere. That's what it shows. 31.
31 doesn't say so. 31 doesn't say so. 31 A, B you are reading, it was out of pocket expenses of authorization for discharge of function.
So this is also out of pocket expenses. Why? What else is this?
Yes, whatever expenditure is being incurred by the AR.
What else is this?
Yes.
Out of pocket expenses are generally those expenses, stationary expenses, travel expenses. These expenses are out of
litigation expenses.
That also is not mentioned that way. That's why
litigation expenses.
Does not out of expenses according to my understanding. If we
are just discussing, and yes.
If there was a regulation on 18 September 2023 also, no? This regulation, this modification.
Sir, now the no time left because only 2 minutes left. My time is
extend kar lenge, Ashish sir, extend
we'll have some another.
We may extend it by the permission of the ICC.
I am going through all these slides. एक बार हम खत्म तो कर लेते हैं उसका 5 minutes.
Please.
ये है with regulation 18, then other provisions relating to year. As I said, the IRP shall apply to the A for the appointment of a year within 2 days of the verification of the claim received under 12(1). Any delay in the appointment of the year for any class of creditors shall not affect the validity of any decision taken by the committee. Then the voting by the abstain class of the home buyers lotteries through the year. Section 21(7) says that the board may specify the manner of voting and determine the voting share in respect of financial debt covered under subsection 6(6)(a). Financial creditor or heir of the heir of the financial creditor, if it is a related party of the CD, shall not have any right of representation, participation, or voting in the meeting of the COC. Regulation 16(a)(7) of the CRP regulation provides that the voting share of the creditor in a class shall be in proportion to the financial debt, which includes an interest at the rate of 8% per annum, unless a different rate has been agreed to between the parties, what we discussed before. The AR shall circulate the agenda to 2 creditors in a class and announce the voting window at least 24 hours before the window opens for voting instruction. Keep the voting window open for at least 12 hours. The voting by the AR, Regulation 25A provides for the voting by the AR. The AR shall cast his vote in respect of financial creditor on behalf of the financial creditor he represents in accordance with the provision of subsection 3 or subsection 3A of the section 25A. No, 25A3A says that mentioning anything to a contrary content in the subsection 3, the AR shall under subsection 6A of the section 21 shall cast his vote on behalf of all the financial creditor he represents in accordance with the decision taken by the vote of more than 50% of the voting share of the financial creditor he represents who have cast their vote. Provided that a vote to be cast in respect of application under section 12, the AR shall cast his vote in accordance with the provision of subsection 3.
So what does this, if at all I can, what does this specifically mean? Provided that for a vote to be cast in respect of an application under section 12A.
12A is with respect to withdrawal of the CRP.
Exactly.
It is the exception of the normal voting. In the normal voting, if a class is voting in majority, like more than 50%, complete block will be considered as the positive voting only.
Right.
If the more than 50% voted in favor, then the 100% block will be considered in favor of the resolution. But exception is a 12A resolution. If in case of voting in section 12A, if the 55 voted in positive, 45% voted negative, accordingly the voting will count. 55% positive, 45% negative.
Got it.
The vote of each homebuyer matters when it comes to voting a proposal to withdraw the CRP. In the case of the Siddharth Build Home or Oriental Commerce, the example of the voting under Section 12A provided in Siddharth Build Home or Oriental Bank of Commerce, when the 40.15% of home buyers voted in favor of the 12A resolution proposed by the Siddharth home buyer promoter to withdraw the CRP against the company, 29.20% of home buyers voted against the proposal. 11.08% abstained from voting. PNB, which held 12.42% vote share, voted in favor of the resolution, while Punjab Sind Bank, holding 7.15%, voted against it. So we need the 90% voting for the 12A approval, and here the voting is less than 90%. Therefore, this resolution must have been rejected. This is in this matter, Siddharth Build Home, they explain how the voting will be computed under Section 12A. So this matter was challenged by the challenge with ANCLED. This is, we understand how we vote in Section 12A. Voting required for the approval of the resolution. Section 21(8) says that the same as others provided in the code, all decisions of the committee COC shall be taken by vote of not less than 50% of the voting share of the financial creditors. Provided where the corporate debtor does not have any financial creditors, the committee COC shall be constituted and shall comprise of such person to exercise this function in such manner as usual. Section 28 provides for the purposes, the resolution mentioned in the Section 28 has to be voted for at least 66% voting share, which are the raise any interim finance in excess of the amount as may be decided by the COC in their meeting, create any security interest over the asset of the CD, change the capital structure of the CD, including by way of issuance of additional security, creating a new class of security, or buying back or redemption issued securities in case of CD is a company. Record any change or ownership interest of the CD, give instruction to financial creditors maintaining accounts of the CD for a debit transaction for any account in excess of the amount as may be decided by the COC in their meeting, undertake any related party transaction, amend any constitutional document of the CD, delegate its authority to any other person, dispose of, permit or the disposal of shares of any shareholders of the CD or their nominee to third parties, make any change in the management of the CD or subsidiary, transfer right to of the financial get operational under the material context otherwise than in the ordinary course of business. So Section 28 was the resolutions wherein we need the voting of 66% and more for the approval of the resolution. Section 22 with respect to confirmation of IRP to RP, we need the 66% voting share. Section 27 for the replacement of RP, we need 66% of the voting share. Then there are many rights of the home buyer in the CRP process. There are many dicey issues, like many home buyers ask for the registration of their unit if they are in the position of the unit. So RP has to decide on the case-to-case basis whether they can do the registration or not. Then they may, in many cases, the home buyers ask for the construction of the project through pool and build method. In many cases, we receive the duplicate claims. Then how to deal with the duplicate claims? It is a very dicey issue because we have the complete documents in both the claims, and we are not the investigating agency to investigate which is the real correct claim or which is the false claim. If the home buyers are residing in the project, there are some issues with when they are residing in the claim. Then how to maintain the project, the maintenance of the society, whether the RP has the power to charge the maintenance of the society if there are some home buyers who are residing in the project. Home buyers can ask for the change of the RP in case they are not satisfied. Home buyers right to ask for the valuation report, IAM resolution plan, in case they want to take decisions on after reading these documents. Then home buyers right to ask for the meeting with the PRS for better understanding of the resolution plan. Home buyers can demand the issues of the Form G project wise. There is new amendment in the CRP regulations for the that the RP can issue the Form G project wise. This is a progression of CIP we all knows. Then what is the status of home buyers during liquidation? Now there is new regulation 46A of the CIP regulation or liquidation regulation. I think this is a liquidation regulation. 46A of the liquidation regulation says that the exclusion of certain assets from the liquidation estate for the purpose of clause E of the subsection 4 of section 36, wherever the CD has given the position to an allottee in a real estate project, such asset shall not form part of the liquidation estate of the corporate debtor. This is the new regulation. Then there is a provision for the compromise arrangement in the liquidation also. Regulation 2B provides for the compromise arrangement. And there is a provision for the selling the asset in the liquidation project on a standalone basis or as a collectively, or the business of the city can be sold as a going concern. So even if there is no resolution plan during the CRP time, liquidator has the power to sell the project of the city as a going concern. There is a provision 32A for the sale of the project as a going concern. The recent amendment by the CRP regulations, which is effective on the 15th February 2024, they intend to bring this IBC provisions in par with the RERA regulations, RERA Act, which says that we have to open a separate bank account for all the real estate projects. New regulation 4D has been injected to the CRP regulations, which says that the mandatory for the IRP or the RP to maintain a separate bank account for the each real estate project. Then there should be a monthly committee of creditors COC meeting, but which also says that the COC has the liberty to decide to extend the interval between the such meetings. The COC wants that no, we cannot hold the meeting, COC meeting in a monthly basis. COC can ask for the COC meeting at a longer period of time. But however, at least one meeting shall be conducted in each quarter. In a quarter, there should be one meeting, and COC has power to extend the interval between such meetings. The voting by the COC. Now the voting window should be opened as per this regulation. RP vote of the members of the COC who did not vote at the meeting of the matters listed for the voting, and such voting was required to be kept open for at least 24 hours from the circulation of minutes. The amendment regulation have now given power to the COC to decide the duration of this voting window, and the same shall be between the 24 hours to 7 days. Further, the RP has been restricted from extending the voting window from where the matter listed for voting have already been received, and the requested majority, and the one extension of 24 hours has been granted after the receipt of the requisite majority vote. The window open extension can be given only for the 24 hours now. Approval of COC for the CRP cost. This is as per regulation 31B. RP has to place in ECOC meeting the operational status of the CD and to seek its approval for all costs which are part of the CRP cost. So the only question arises, so what is the meaning of the all cost? Should the RP has to place all the CRP expenses till the COC meeting before the COC, or only the new expenses which is to be ratified by the COC? This is a question. I think only the new cost to be ratified by the COC is to be placed for the ratification for the COC.
For all the new.
And RP, I think, should place the details of all the CRP expenses till date as an annex to the notice of the COC meeting or as a part of the COC minutes. Disclosure of valuation methodology by the resident valuers. So now the RP has to invite the valuers who will explain how they had computed the valuation or the methods through which they had come out with this valuation of the corporate debtor. It is duty of the valuers now to explain this COC how they come out with the valuation number. Disclosure of the valuation report. Now, as per these new regulations, they say that the fair value should be part of the IM. However, the members are required to give an undertaking to the effect that they shall maintain the confidentiality of the fair value and the liquidation and will not use the such voters to cause an undue gain or undue loss to itself or any other person. Next is a disclosure of fair value in the information memorandum. Under the CRP regulation, the RP is required to submit the IM and fair value has also been made a part of the IM, although the COC has been granted liberty to not disclose the fair value if it considers such non-disclosure to be beneficial for the resolution process, provided the reasons were not recorded in writing. Now the fair value should become part of the IM if the COC feels otherwise with reasons. Any invitation of the expression of interest for the real estate project. Now the RP is about RP can issue the Form G for the separate Form G for separate projects of the corporate director. Monitoring committee of the for the resolution plan implementation now as per new regulation, while the CRP regulation amount payable and monitoring committee for the implementation of the resolution plan. If the COC considers that such monitoring committee is required, it has been given the power to constitute the same with the RP or the propose another IP or any other person as its member. If the RP is made a member of the monitoring committee, the monthly fees payable to him shall not be more than monthly fees received by him during the CRP process. Continuation of the CRP process during extension application. The CRP regulation provides that the COC may instruct the RP to make an application to the A to extend the CRP process. CRP and RP shall make an application upon such instruction from the COC. This is all about the slides. So if anyone has any question, they may raise, or we may conclude with this meeting.
Thank you for your session.
Thank you, sir. Thank you, sir. Thank you very much. Anjali ma'am, yeah, are you here?
So there was some question, there was some clarification was required as per the CIRP cast of AR. So we can discuss on it if somebody wanted to discuss.
Yes, sure, sir.
So if you see the new regulation, just I got the new regulation. If say regulation 6 16A, the new amendment has been come. PC 8A. It read the authorized representative of creditor in class shall be entitled to receive fee for every month for committee attended by him in following manner. Then thereafter it says the authorized representative shall be entitled to receive for every meeting of the class of creditor in the following manner. Then it is very important. 3.4. The payment of fee authorized representative shall be part of insolvency resolution process court in respect of 2 meeting with the creditors he represent corresponding to a meeting of committee of creditor. Please see the IBBI is specifying everything. Then second, the fee for any additional meeting beyond 2 meeting corresponding to a meeting of the committee of creditors shall be part of insolvency resolution process cost subject to approval of committee, then approval of committee of creditors. After sub-regulation 9, the following shall be inserted, namely the authorized representative shall assist the creditor in a class he represent so-and-so, then review the content so-and-so, help the creditor of class in so-and-so, then assist in class, work in collaboration, assist in class, ensure, para F, ensure that the creditor in class he represent have access to information, then update regularly, make suggestion, record proceeding, act as a representative. The provision of minutes of manning so-and-so, the creditor in a class may propose additional responsibility upon the authorized representative in relation to representation of their interest in the committee. The 12th part only is this says so therefore, the specification with respect to other costs is not there. The regulation talks about how the AR will be paid, and even in the payment, if there are more than 2 meetings, the ratification of COC is required. So this regulation is silent about AR engaging another counsel.
No, but just because it is silent doesn't mean it is not there.
How can it be? I don't
See, I
think
tell you one example, Shirendraji.
if it is happening anywhere.
I am AR in one company,
Yes, yes.
and the IRP has adopted the the procedure
Hmm.
कि any expenses made by the AR on account of litigation will be a part of the CRP cost.
Hmm.
Simply. क्योंकि the reason is I'm getting 40,000 for my one meeting, and the lawyer fees is 40,000, 30,000, 20,000, 25,000 per hearing. From where I'll bear the cost?
Okay. If it has happened, let's see.
Yeah, it is. These are being adopted by the RPs.
So in that
This
case, whether
practice.
RP has actually the RP has selected the counsel, you yourself have selected the counsel.
It depends on me as well as him. He told me you select your advocate
Okay, it's okay then. If it is
and submit the bill. He'll pay the bill.
of course, if it is ratified, if you put the same in
Yes, it has to be ratified by the COC. Correct. Yes.
COC say something, so it can happen.
Yes.
But regulation doesn't say so. It doesn't talk about engagement of counsel. According to my understanding, I've read somewhere. I'm just if suppose a counsel has to engage, that cost has to be borne by the creditor in class. They will pool their fund out. If all the creditor in class are there, they will pull out the fund from their own sources and they engage the counsel.
I think, sir,
If
we
it is
should
ratified, there
conclude
is no
now.
problem.
The time is up.
Pardon?
And I think we should conclude now. The time is up.
Thank you. Thank you. Thanks for this.
Anjali ma'am, if you are here, Anjali ma'am.
Thank you for the
Thank you
meeting.
so much. Thank you so much,
Thank you
Ashish
very
ji.
much.
Thank you.
It was
Thank you.
smooth,
Thank you very much.
healthy discussion. Thank you
Thanks.
so much.
Thank you.
Thank you all. Thank you.
Thank you. Sir, I was hello, all. I was under impression that my timing was till from 2:30 to 4:30, but I've been informed that my timing is till 5:30. So I can continue if you all agree. Hello.
Sure. Yeah, yes, sir. Please continue.
Yes, sir. So because many has left now.
Can we discuss some
Regarding-
successful resolutions which have happened, sir? Or how does a home buyer actually tries to resolve this thing? And any efforts made by home buyer, which is to your knowledge, they form a group and try to do something which NCLT approves, something different.
Yes, yes.
Other than the routine. I mean, that's what, if we can contribute positively in that field.
So I'm just opening my PPT, sir. Just wait.
Sir, am I permitted to share my experience, sir, in home buyer matter?
Yes, sir. Please, sir.
Sir, I am RP of Sheltrex Developer Private Limited. The CARP commenced during December 2019, and till date it is going on. Reason being, I submitted resolution plan for the second time. The point here is during September 2020, I filed an application with NCLT with 2 prayers to constitute COC project wise, to issue EOA project wise. But say NCLT took 18 months time, and during April 2022, they rejected both of my prayers. Then I once again made EOA, and finally during November 2022, I filed one resolution plan. But there are 2 resolution applicants because the company's liability is very huge. So for project A, the affected home buyer itself formed the association and gave plan, and for project B, the resolution applicant is outsider. Again, after giving my resolution plan during May 23, NCLT directed me to take a big claim of 200 crores that of corporate guarantors. So again, I took that, and in this September month, once again, I submitted resolution plan, second time with 96% vote approved. Now the resolution plan approval is dragging in NCLT due to one secured financial creditor with vote share of 1.5% or 1.3% is fighting in the NCLT, and the NCLT could not take decision. Even though it is approved by 96%, still it is going on, sir.
What is the reason for pendency, sir, before the NCLT?
Sir, 1 minute. Sir, please repeat.
What is the reason for pendency before the NCLT, sir?
Sir, they are afraid, honestly, they are afraid of taking decisions, sir, because of that 1% creditors, or 1.3% creditors, sir. The plan was approved with 96%, but still they are reluctant to take a decision. It is almost 7 months over. Next hearing, they gave date as April 16th. Every time they will tell you come for physical hearing, but in the cost list, they will tell it is only an online hearing. So if I miss next hearing, and then May month, 2 weeks NCLT holiday, it will go to June. But I was trying for project wise during September 2020 in the midst of COVID wave, because the liability was huge and nobody want to take that. In total, nobody want to take it.
There are many complicated cases in the insolvency process, like normally the land bank is in the name of the subsidiary company of the associate companies. Now I have received a resolution plan which says that the land owned by the subsidiary company of the wholly owned subsidiary company will become part of the corporate debtor, and accordingly they had given the resolution plan. Though there is no objection on this part of the resolution plan, but this is a big issue. How
Yes,
a PRA can claim on the land which is owned by the other company. Though it is a wholly owned subsidiary, it will come to the SRA only through the shareholding. But before the approval of the resolution plan, how we can take stake on the company land owned by the subsidiary companies. But if he don't take the land, because project is made on the land on the subsidiary companies, because therefore he has to take into account the land, these lands also. Otherwise, he cannot give the resolution plan. How will he will make this project of the for the corporate debtor? This is the one issue, major issue in the real estate companies.
yes, sir. Yes, sir. Correct, sir.
So, sir, I can have a detailed discussion on the PPT itself, because PPT is not complete. I just gone through on the PPT.
So you can go through the balance PPT, sir.
Yes.
Please, sir.
Yes.
Thank you.
So it is visible, sir?
Yes, sir. Visible, sir. Visible.
If anyone has friend who has left now, may ask them to rejoin. I may.
Sir, you can run through the PPT, sir. Whatever you completed, you can scroll, sir.
So we are discussing detail the right of home buyers to file application. If we can have discussion on this rejection of the claims.
Sir, please go to previous slide, sir. The PU shelters heading.
Yes,
PU shelters.
yes. In this, the e-voting on the proposed, this is matter I explained earlier also, that this is a issue when the
Yes, sir.
RP
Yes,
has
sir.
filed a resolution plan before the COC, and then this plan was approved by the NCLT also.
Yes, sir. Got it, sir. Got it.
Yes, and then the suspended directors has filed appeal before the NCLAT.
Got it, sir. Got it, sir. You can go to the next slide, sir. Please.
We had discussed the voting of by the absent class of home buyers.
Yes, yes, sir.
How voting can be done in the section 12A case we had discussed.
Correct, sir. Correct.
We can discuss this part from this part onwards. Voting
Correct.
required to approve the resolution. So there are many provisions in the IBC code which says that the different voting requires for the approval of different resolutions. Generally, that section 21(8) provides that the same as otherwise provided in this code. All the decisions of the committee of creditors shall be taken by a vote of not less than 51% of the voting share by of the financial creditors. Provided where a CD does not have any financial creditors, COC shall be constituted and shall comprise of such persons to exercise such function in such manner as may be specified. So generally, the COC can take decision by vote of not less than 51% voting share. If anything is not prescribed in the code or the regulations, then we have to pass a resolution by more than 50% voting share.
Correct. Correct.
Section 28 provides that for the resolutions or the issues to be put for the e-voting or the voting, then the COC has to pass these resolution by not more less than 66%. So what are these resolutions we can discuss in detail.
Yes, sir. Yes, sir.
First one is to raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. So in the interim finance, if the COC by resolution says that they can accept the interim finance up to 10 CR. Then if this 10 CR resolution can be passed by 50% voting, more than 50% voting. But after the passing of this resolution, if the COC thinks that they need to take more amount as the interim finance, then I think this will fall in this provision section 28, and they have to take the approval of at least 66% of the COC. Then the B says that the creating any security interest over the asset of the corporate debtor. Like in the real estate companies, if you want to take the interim funding, it may be secured, it may be unsecured. So RP has the power to take the funding from NBFC company or any other person, and that funding can be secured one, but it should be approved by the COC of at least 66% voting.
Yes.
Like in the pool and build thing, if you want to, if any RP had heard that many RPs are in the process of construction of the project by taking the amount from the home buyers for the purpose of constructions. But if the amount raised from home buyers are less what is required for the completion of the project, then the RP can take the interim funding and by securing the asset of the CD. And for giving security, he has to take the approval of the COC by not less than 66%.
Yes, sir.
Then they change the capital structure of the corporate debtor, including by way of issuance of additional securities, creating a new class of securities, or buyback or redemption of the issued security in case of the corporate debtor is a company. So say this is not heard or this is not done till date, I think. But if any COC wants to change the capital structure of the company for any reasons, then they may do so, but they have to take the approval by the 66% COC voting. Record any change in the ownership interest of the corporate debtor. So in the case of the corporate debtor, if the COC wants to change the ownership interest, then they can do so by under this section 28. Then give instruction to financial institution maintaining accounts of the CD for a debit transaction from any such account in excess of the amount as may be decided by the committee of creditors at their meeting. So, in case the COC decides that the accounts maintained by the corporate debtor can have maximum debit balance, debit transaction of not more than say 1 lakh rupees. If any check presented before the bank for more than 1 lakh rupees, or the RP wants to clear a check of more than 1 lakh rupees, then he has to take the approval of the COC under this section 28 by approval of 66% voting. Undertake any related party transaction. Say that if any company is a operating company, corporate debtor is a operating company, and they are taking the raw materials from any related party. And for the continuation of the operation of the corporate debtor, it is necessary to take the raw materials from that related party only and to continue with this related party transaction. So for the benefit of the corporate debtor, COC can approve this kind of resolution by 66% and they may continue the related party transaction. Then they amend any constitutional document of the corporate debtor. So they may amend the constitutional document like the MOU of the corporate debtor by under this section by voting of 66%. Delegate its authority to any other person. If say RP wants to delegate its authority due to any reason, then he may do so and with the approval of the COC by 66%. Dispose of or permit the disposal of shares of any shareholders of the CD or their nominees to third parties. So they are COC can agree or can allow the disposal of shares of any shareholders of the CD or the nominees of the shareholders of the CD to third parties under this section. To make any change in the management of the corporate debtor or its subsidiary. This is very important. RP has the power to place a resolution before the COC for the change in management of the subsidiary companies for the corporate debtor or the subsidiary company. For the corporate debtor, RP is the in charge, but for the subsidiary company, RP is not in charge. But RP has the power to take control of the management of the subsidiary company. So he may place a resolution before the COC, and if the COC approves by 66%, then he may nominate his own persons or his representative as the directors of the subsidiary company. Through this way, he can control the subsidiary company. And why this control is required? Like I said, that there may be cases of that the land is owned by the subsidiary company and licenses is in the name of the subsidiary company. Then we may have to apply before the various authorities for the renewal of licenses, and this renewal of license can be done only by the subsidiary company. Therefore, this clause is important for the RPs that they can take the control change in the management of the subsidiary companies. Transfer rights or financial debts or operational debts under the material context otherwise than in the ordinary course of business. So if any transaction took place which is not in the ordinary course of business, then the COC may permit it by the voting under this section. Make changes in the appointment or terms of contract of such personnel as specified by the committee of creditors. Make changes in the appointment or terms of contract of statutory auditors or internal auditors of the CD. The terms of the contract of the statutory auditors or the internal auditors can be changed by the COC under this section. Subsection 3 of section 28 says that no action under subsection 1 shall be approved by the COC unless approved by a vote of 66% of the voting share. Where any action under subsection 1 is taken by the RP without seeking the approval of the COC in the manner as required in this section, such action shall be void. The COC of creditors may report the action of the RP under subsection 4 to the board for taking necessary action against him under this code. This is all about section 28. Then there is a provision in section 22 which also says that the for the confirmation of IRP to RP, at least 66% positive voting share should be done by the COC for this change. And if the COC wants to replace the RP, then this replacement of the appointment of new RP should be approved by at least 66%, subject to written confirmation by the proposed RP. This is all about the voting in the COC. Then we had discussed the right of home buyers in the CRP process of the real estate company industry. And IRP is required to be appointed at the time of admitting the application of the insolvency resolution of the CD in accordance with section 16 of the code. However, the name of the IRP is to be proposed by the financial creditor in the application itself to be filed in section 7 of the code. There are some rights that may be exercised by the home buyers, which may be the registration of unit, including plots and flats in case of possession of the unit handed over to the home buyer. There is some proposal of the report, report from the IBBI, which proposed that the RP has the power for the registration of the unit if the unit holders has the possession of the unit. But that is not been amended in this recent amendment. This not become the part of the CRP code. Then the pool and build of the project of the CD. In many cases, the position of the project is very bad, and it is in very bad shape, and it is urgently required to renovate the construction part of the project. In those cases, many RPs has taken steps for the renovation of the construction of the project. In those cases, the funds required for the construction of project can be arranged by either by taking the interim finance or by taking the funding from the home buyers. And it has been seen that in many projects, home buyers has contributed for the construction of the project, and through that pool of the receivables from the home buyers, RP has commenced the construction of the renovation of the project. This home buyer may ask from the RP for the, in case the position of this project is in bad shape. In many times it has been seen that we received a duplicate claims for the same unit. In my cases also, I received duplicate claims for different projects for the same units. But since we can verify it from the CRM data or from the various other documents of the corporate debtor, and accordingly we can adjudicate the claim of the, not adjudicate, we can verify the claim. But in many cases, the records of the corporate debtor is not available. In those cases, RP don't have any other option but to admit both the claims on the same units. Then and keep the decision for the PRAs to decide what to do with these duplicate claims. If the home buyers are residing in the project, in many cases it has been seen that the home buyers are residing in the same project. So what to do when the home buyers are residing in the project? Then all the responsibilities with respect to the infrastructure in that project comes to the RP, and he has to see that all the infrastructure in the project is in a good shape. Like if this is a multi-story building, then RP has to see that the lifts are working in a working condition, and all the everything is proper for the continuous residence of the home buyers who are residing there. In case any accident or anything happens in the project, then it is a responsibility of the RP to bear the implication of those accidents. Therefore, it is very necessary for the RPs that all the infrastructure in the project are in good shape. Maintenance of the society in case such project where the home buyers are residing. In case the home buyers are residing, then it is necessary for the RP to maintain the society, and many things are required for the maintenance of society. Like there should be a proper electricity in the society, there should be water supply, the sewerage system is good, STP is working in a working condition, the roads are there, and he has the duty to upkeep the project. So how this maintenance cost RP can generate? So he don't have any other option but to take the maintenance from the residents of the society who are the home buyers and who has filed their claim. Even when the any home buyers who has not filed his claim, then he can ask for the maintenance from that home buyer also, because he is using the services of the uh, providing for the project. Home buyers can ask for the change of the RP in case they are not satisfied. RP, the home buyers has the power for the asking for the change of the RP in case they are not satisfied. As we discussed, there is a provision which says that by the 33% voting, they can ask RP to put a agenda before the COC meeting and put that agenda also in for the voting. And RP will be bound to put that agenda, which may include the change of the RP. And for that thing, the home buyers has to provide the consent from the new RP, and RP in the agenda will place everything before the COC members, consent form, eligibility of the new IP, and he is eligible to become the RP of the company, corporate debtor. And after satisfying the same, the previous RP, the RP can put it before for the discussion in the COC meeting and also for the e-voting by the COC members. And if this resolution for the change of the RP is approved by the COC members by 66% as per section 27 of the IBC code, then they may approve they may change the RP. The COC or the new RP will file application before the NCLT, and once the NCLT will approve the application, the RP will take the role of the RP in the corporate debtor. Until then, S2L RP will continue with the functioning of the as a RP. Home buyers right to ask for the valuation report, IM resolution plan. So home buyers has a right to ask for the valuation report, IM and resolution plan if it is required to take decision on the voting on any resolution items which include the resolution plan. Home buyers right to ask for the meeting with the PRS for better understanding of the resolution plan. So home buyers has all the right to ask for a meeting with the PRS for better understanding of the resolution plan, and then the RP has a duty to arrange for a meeting with the PRS. Many times, because home buyers are not a technical person, he cannot understand the resolution plan. In those cases, they may ask the RP to arrange a meeting with the PRS, and the PRS then, through virtually or physically, a PRA then can explain their resolution plan in a better way, and they may resolve all the queries of the home buyers. And once the home buyers are clear about the resolution plan, and with this clarity, they may vote accordingly on the resolution plan, which is better for them. Home buyers can demand issuance of Form G project wise. Now, as per the new regulation, home buyers can ask for the issuance of Form G project-wise. And RPA has a duty to issue the separate Form G for separate projects. Then progression of CRP after the date of admission of the application. CRP is to be completed within 330 days from the date on which the application has been admitted by the adjudicating authority after Section 12 of the Code. IRP gets appointed at the time of admission application of Section 16, and a moratorium is also pressed into effect under Section 14 of the Code, pausing all the pending and contemplated legal action against the city for the recovery of debts. RB make a public announcement in Section 15 of the Code about the launching of the CRP against the city and calls for the proof of claims by the creditors immediately after he assumes the charge under Section 13 of the Code. RB constitutes a committee of creditors and to hold the first meeting of the COC within 30 days of his appointment, and a regular resolution RP gets appointed in the very first meeting itself. This is all about the CRP process. So we have discussed the home buyer status during the liquidation time. So if anyone has any query, we may discuss the queries.
Yes, sir. I have two queries.
Yes, sir.
Yeah, first is that pertains to regulation 16A9. So which says that AR may seek preliminary views, and thereafter it also talks about opening a window for 12 hours after 24 hours of seeking preliminary view. So what is the way of seeking preliminary view?
Okay. So sub-regulation 9 of Section A says that the
Yes,
AR
sir.
shall circulate the agenda to the creditors in a class, and he
And
may seek their preliminary view on any items in the agenda to enable him to effectively participate in the meeting of the committee. So
Yes.
once the
And
AR receives the notice of the COC, and then he has a duty to
yes, sir.
circulate it before the class of the home buyers. And
That
through Google
that
form,
is
you must be knowing of the Google form, through any other mode or through a meeting with the members of the class of the creditors. He may seek a preliminary view on any item of the agenda. Like now, because this AR has to do the voting as per the instruction of the class of the home buyers. So he can have a meeting with the class of the creditors. He may discuss the agenda items with the class of the creditors, and if the class of creditors unanimously says to the RP that he wants to consent, approve or the disapprove any particular resolution, accordingly RP has to act. Or if it is not possible because of the number of creditors in the class is used, then in those cases he may circulate a Google sheet or some kind of this sheet with the home buyers and ask for their view, and in accordance with the view of the home buyers he may take a decision while voting on the particular item of the agenda on which he has to vote on behalf of the home buyers.
okay. And second question is pertaining to the recent amendments, which inter alia talks about the submission of project-wise resolution plan. So what is the way forward in that direction? Project-wise insolvency?
So if the corporate debtor has more than one project, like in my one case, CD has 3 projects. One project is attached with another project, and that second project has been sold by the corporate debtor just before the commencement of the CRP.
Mm-hmm.
earlier, before the coming of this new regulation with that the new separate Form G can be issued for separate project. So we had not, as a RP, had not received the claims from the home buyers of the project which has been sold just before the CRP. So we had filed application before the NCLT that since we had not received claim and we had filed necessary avoidance application before, which is pending before the NCLT. Therefore, once it is decided that this project will belongs to the corporate debtor or not, we should not issue the Form G. Otherwise, what will happen that the home buyers of the project which has been sold will be excluded from the CRP process. So we had also filed the exclusion application to exclude the time which is taken during the pending the disposing of this application, avoidance application. The Honorable NCLT had excluded that time, and we had not issued the Form G. Now, after the coming of this new amendment, we can issue the Form G for these two projects, and this issue with respect to the project sold just before the commencement of CRP will remain pending with the NCLT. So now RP has the power to issue separate Form G for separate project. This way it will also be easier because many PRAs can come for a particular project, but if you give a complete company with many projects, I think few PRAs will come. I think better resolution plan and the time value, we can maximize the valuation of the corporate debtor by issuing the different separate Form G for the separate project.
But all the assets and liability that have to be segregated among the projects. So that
Correct.
would be a difficult task, don't you think
Yes,
so?
yes. No, that is a very relevant question. We can issue the Form G for separate project, but there is a common liabilities for the corporate debtor. How to segregate the liabilities, and there is also issue with respect to voting on the form or voting on the resolution plan for a particular project.
Yes.
Whether this complete COC will vote for the particular project, or only the home buyers of this project only will vote for this on the resolution plan received for this project. This is not provided in the code or the new regulation, and there is no clarification on this. Therefore, I think since the more clarification comes for this, we should have the voting done from the complete COC of the corporate debtor.
Okay, thank you.
Thank you. Anyone has any more queries? Anjali ma'am, you are here?
Yes, sir.
Now I think we can conclude with this webinar.
Sure, sir. We can conclude.
Yes. Thank you all. Thank you all.
Thank you very much, sir, for such an insightful and interactive session. Looking forward for more sessions with you. Sir, you are requested to please share your presentation with me so that I
Yes,
can
sure.
forward it to the participants.
Sure, ma'am. Thank you. Okay. Thank you all.